It is kind of like a choice. Yeah, that'd be fine. Or could it be dull when I want it to be dull? Yeah.
Get your thoughts together, my friend. Yeah, I've argued this shit hundreds of times if I never figured it out now. I'm never going to. I was trying to think of what new and clever argument Mr. Reticchio was going to come up with.
Anybody? Thank you.
Absolutely, thank you, sir. Appreciate it.
Maybe we should start better. Yeah.
I know.
It is. If you have to live in other people's.
That's right. If I have to live with this, everybody else has to. Yes.
Heard the name.
Oh, there you go. That's before my time.
Oh, I hadn't heard. Really?
I just heard it.
Well, the face was fine. 87.
Yeah, I mean, I don't know.
87. Yeah, and I started working.
I know he mentioned Carol Ashley.
Yeah.
She was on a champagne class today. She did all those. Carol Ashley.
Yeah, sure.
Yeah. We had a piece with her for champagne. It was the class and she did for years. I mean, decades.
Yeah, I don't know her from that rock. No.
She was a baby associate, I think, during the Rockford case.
No, I don't know that. Unless she came in later before I, because I like her. I do the whole or in case you still don't
Once
have
again,
it.
folks, I'm gonna ask you to make sure that your phones are off, so we don't kill the feed. So many people on the Wi-Fi. Appreciate it. Thank you. There's a lot of hot air in here today.
Don't make fun of Mr. Virginia like that, man. I'll defend you.
I'd rather go closer.
That's good.
And there's no new attorneys. Everyone was here this morning, right?
Profound words of wisdom.
Yeah, I can tell. Yeah, I can go, it doesn't matter.
I'm fine with just that.
Yeah, I can go.
Can I switch out with you?
Not at all.
When are you?
You can switch on me now if you want to be able to take notes better.
I don't need to take notes.
Okay.
That's okay.
No, yeah, of course, you can switch on me whenever.
Thank you.
And just take notes at this point. Did we open up during like
Yeah, a lot more microphone. Apparently they didn't have notice in IT that they were here today. So they had to scramble about 30 minutes to set up if they could.
There was not, no. They just rolled it up. I would take it as one.
I think we're gonna have a.
We have to be the ones tasting that.
Yeah.
We're the ones trouble at elbows.
Oh, we're all in the room, I think is the
Are you
problem.
just gonna sit up here now? You can like get stuff set up. I really don't mind. You're not
Are you sure?
not at all.
I feel like it's
I'm like,
first
I
come,
did not.
first serve.
No, I just took it because it was before we had to be chairs, and it was just one for open. You need the space more than me.
Jason was just saying, do you want to go first? I'm like, I'll be even right here.
I lost it on my phone.
Yeah.
Communication. Well, it shouldn't be with everybody else in the room.
To just suffer.
Not to mention yours.
Save the best for last. I'm not sure whoever you're going to go last. But
I don't know how I would set it up if I was a.
So let's take a number.
yeah. We have enough body heat in the room?
It's worse than yesterday.
So do you guys, do you know all this? Do you guys do the brotherhood?
Yeah, it's not a very big club, you can imagine. The school owners,
You don't want it? You want it?
he wants a better view of everyone's behind. That's what he's getting. You want a better view of everyone's behind. That's what you're getting now.
A bunch of my colleagues just started texting me going, what happened? We can't see you. I don't know why they want to. You're free will, man. You don't screw I will. It's there for their reason. Was it there this morning? No. We didn't get a plan much of this. Yeah, I don't know those things.
Thank you, everyone. Have a seat.
I'll have to get a new piece of paper. Just a second. Okay. All right, counselors, I have to disclose to you over the lunch hour, I am now at 80 emails that I have received from citizens who are in the minority, is what the emails are claiming. There was one that said majority, but they're all expressing their interests. I've only opened a few. I get enough emails as it is, so I have not opened the other ones, but I felt I need to disclose that to the attorneys, and they keep popping up. I don't know how they got my email, but they're just populating right now. No, I want that on the record. I'm sorry. Let's go on the record. I had just disclosed to the attorneys that over the lunch hour, I started getting emails. I'm now up to, I opened a few, but now they just keep populating, getting emails from individuals. Some are entitled minority, one says majority, I read 2 and then I closed them. They're also calling and emailing my assistant and sending emails to her expressing their opinions on this case. So I felt I must disclose this to everyone. I read a few, but the majority of them I haven't, because as you all know, I get enough emails from all of you. So, Mr. Peticchio, you were going to say something.
I was just wondering if you're going to make them of record, Your Honor.
I will.
If you're going to read them, I would request that you do.
Right.
If you're going to delete them all, then no problem here.
I would think you just delete them all, Judge, but you do what you think's best. I don't think they'll have any sway on you one way or another, but whatever you feel is best, I don't have a problem.
I will, I'm not going to open them now. Like I said, I did open a few, and I can tell which one of those I opened. So those I will make part of the record. And then I think my secretary forwarded me a few. Actually, why don't you go tell her not to forward me anymore until I decide.
My only point, Your Honor, is I'm not sure we need to make this a contest.
Right.
I agree.
Because once
It's
word
about the
gets
law.
out, hey, if you want this, send the judge an email. If you want that, send the judge an email, which is really irrelevant to your issues.
Right,
So
exactly.
If
I
you
do.
just assume dump them all, it's.
I understand this is a passionate issue. I do. I get it. But my ruling will be based on the law and the evidence that's presented in this courtroom. So,
Absolutely.
but I felt I needed to disclose that to everyone. The easiest thing for me would be to delete them. But regardless, I will make a docket entry on that as well and let everyone know. I'm not going to deal with it right now. I want to deal with the issues that we're here to deal with today. And I wish I could now have to turn off my notification so it doesn't come up, but I don't know how to do that. Regardless, we are here today now to commence arguments on the motion for TRO. As we indicated, I'm going to re-indicate this morning because the court reporter is going to do a transcript for this morning, which is primarily on the class certification. Then today this afternoon, we're taking up the TRO issue. And so as we discussed this morning, the record from Monday in 5007 will be made part of the record in these cases, which is 5002, 5003, 5005. And then these 3 cases will also be made part of the record in 5007, so that we don't have to have duplicative arguments of what we had on Monday, and that we have a full, complete record for all the cases. Did I adequately represent that, counsel?
Yes, ma'am.
Yes, ma'am.
Plaintiff.
Okay.
Yes, Your Honor.
Nodding heads
Yes,
from
yes.
the defendants as well. Okay, wonderful. I apologize for the heat. I'm trying to get it cool in here. If you want to take your jackets off, that's fine. It's very warm in here. Don't worry about it. Just make yourself comfortable. I don't want anyone passing out. I would, counsel at the table, you can stand and speak. Everyone else who's back in the galley, if you want to speak, would you please come up to the podium? It assists the court reporter when she's taking down the record. And I know it's probably awkward sitting back there anyway, trying to stand up and argue and look at your notes. So we're going to do our best to get through as much as we can today. So with that, I guess it's your motion, Mr. DeVore.
Thank you, Judge. Your Honor, I had this here for you as a few things that I wanted you to review, and what I had already printed off, it really made me think when I was listening to Mr. Peticchio talk about majority and minority, and I think that probably primed these massive responses that you unfortunately are getting. But that to me is a sensitive topic, because that whole conversation is premised upon us being a democracy, of which we're not. We're a republic. So minority, majority makes no difference. There's a case that I'd like you to read before you rule anything in these cases. This is a United States Supreme Court case. You may have studied it in law school like we all did. It's the steel mill cases from the Korean War. 343 U.S. 579. Youngstown Steel. United States of America was at war with Korea. And the president, using his executive power, seize control of all the steel mills because we were at war. Steel mills went on strike, and if we didn't have steel mills to make steel, we couldn't have planes and our country would be taken over. That was the arguments made by the president when he issued his executive orders. And I would ask you to read Justice Douglas's concurring opinion. I got a piece of it here. But it's really, Judge, this was 70 years ago. And I would hope we haven't gone so far in 70 years that we forgot the very premise of which Justice Douglas was saying. And it's brief. There can be no doubt that the emergency which caused the president to seize the steel plants was one that bore heavily on the country. But the emergency did not create power. It merely marked an occasion when power should be exercised. And the fact that it was necessary that measures be taken to keep steel in production does not mean that the president, rather than the Congress, had the constitutional authority to act. Congress, as well as the president, are trusted with the national welfare. The president can act more quickly than Congress. You've heard that in our state, how Governor Pritzker can act more quickly. The president has services at his disposal. He can move with force as well as speed. This is one of the best lines. All executive power, from the reign of ancient kings to the rule of modern dictators, has the outward appearance of efficiency. Legislative power, by contrast, is slower to exercise. There must be delay while the ponderous machines of committees, hearings, and debate is put into motion. It takes time. And while the Congress slowly moves into action, the emergency may take its toll on wages, goods, standard of living, and perhaps even lives. Legislative action may indeed often be more cumbersome, time-consuming, and apparently inefficient. But as Mr. Justice Brandeis stated in an earlier Supreme Court case, the doctrine of separation of powers was adopted by the Convention of 1787 not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of inevitable friction incident to the distribution of government power among these departments to save the people from autocracy. Ma'am, that was written 70 years ago, and it's what we're dealing with today in this courtroom. Every argument that you're going to hear Mr. Verticchio make runs contrary to the concurring opinion of Justice Douglas. Now, what we're asking for the court to do is to uphold the due process that's in the law. You're likely going to read cases that have been brought forth by my colleagues on the defense. Some of these cases where they said procedural and substantive due process under the Constitution don't apply to these circumstances, etc. We're not talking about that. We are talking about specific statutory provisions that were adopted by the legislative branch of government of the General Assembly of this state. And we're asking you to apply those that were specifically crafted to the circumstances of which we now face ourselves. They were crafted for it. When we're trying to limit the spread of an infectious disease, is the language that I'm going to be reciting to you out of the law. That's what we're talking about here. And I've stood in your courtroom for what, a year and a half on various circumstances now, and we still keep hearing the same thing, Judge. Oh, we've got the emergency and the governor and the governor. How many times has our legislative branch of government had the opportunity to change the law, and they haven't done so? Now, we're going to talk, not just briefly, because Your Honor's already heard it ad nauseum, but just briefly I'll touch upon the emergency rule. This is what Judge Tromper had to say. These agencies have...
I'm sorry, Your Honor, again, if Mr. DeWar doesn't mind, we know that Judge Tromper had multiple rulings. Can we just have the date of the order? It's just
November 22nd, when she granted, November or September 22nd, 2021, she granted a preliminary injunction.
Okay, thank you.
These agencies have had approximately 550 days to make amendments to 77 Illinois Administrative Code 690, which is the Department of Public Health rules.
Yep.
But instead chose to wait until litigation was well underway and then once again have changed the goal line. Courts cannot turn a blind eye to our founding fathers' wisdom in creating three separate but equal branches of government. The government must work efficiently while ensuring citizens' rights are protected. Each branch of government has the power to check the other two to ensure that not one branch becomes too powerful. That was her brief remarks. And again, she never had the chance that you have to address this emergency rulemaking, because while also on that date of September 22nd, when she entered the motion to certify the class, she entered a preliminary injunction that I just read out of. She also entered an order, in her opinion, saying that the governor was a necessary party to her cause of action and the state agencies. She never got a chance to get into these emergency rulemaking because the case got pulled from her court. Now it's in yours. But she certainly brought up one of the arguments that I made to you earlier about what's the emergency. And you asked that question day before yesterday on numerous occasions. I don't think you ever got an answer, ma'am. Although I believe we know what the answer is. Your Honor, we have in these counts, we're asking the court to find under the Department of Public Health Act that, and I'll get to the details, but that masking and exclusion from school cannot be accomplished without due process. I can reduce it down to that. Now, on the opposite side of that, you're going to hear, well, the governor's executive order gives the power to school districts to do these things, because the school districts are the ones that are doing it, right? Mm-hmm. Now, there's 146 school districts in this case. The reason that they're in this case is because regardless of the mechanism behind the scenes, they're the ones that are actually doing it, right? When Governor Pritzker issued his executive order, school districts had a choice. Mr. Feeney and I have argued this before. They had a choice. They could stand up to the governor and the agencies and say, you know what? We're going to do what we think's best. Whether it's legal or not, it's separate, but we're going to control locally. They could have done that. Most of them didn't. And for that reason, they found themselves in the middle of this. Again, Mr. Feeney and I, gentlemen, have argued this, and I understand where the school districts are at on that. But they put themselves in the middle of it, because once they chose not to stand up to the governor, that left the parents with no choice but to have to do it themselves. And so they're named defendants in these cases because they're the ones implementing the policy. Now, that policy that they're implementing, is it lawful? We say no because of the Department of Public Health Act. If it is lawful, where do they get the authority? Again, from the governor's executive order, from the rules of the Department of Public Health or the State Board of Administration, or from their own inherent power, which again, Mr. Swain was talking about earlier. It's our position that none of those authorities give them the ability to disregard the Department of Public Health Act. That's what we're going to argue. So the court's going to have to analyze that, though, I believe, separately. Do the state agencies have the ability to compel this? Regardless of that, do the school districts have the ability to do it themselves? Now, just briefly, Your Honor, we pointed, and I'm not going to spend a lot of time on them, as to the issues of the state agencies. As to, on count 7, the IDPH emergency rule is not lawful authority for which school districts can base their mask and exclusion policies. This emergency rule that was issued on September 17th, what did it do? It stripped out modified quarantine. The language within modified quarantine listed as examples. Exclusion from school is a type of modified quarantine. It also listed a device intended to limit the spread of an infectious disease. Judge Grunke, Judge Jarman, and Judge Schieffer all found that a mask was a device intended to limit the spread of an infectious disease. Hence, the Department of Public Health Act controlled due process was required. Irrespective, now granted at the time, the state agencies weren't parties, that's true, but those judges considered that state authority that the school districts argued, they just didn't find it acceptable. But this emergency rule, Judge, you have to look at this emergency rule and ask yourself, procedurally, is it appropriate? And substantively, would it be appropriate? If you don't get past the procedural propriety, whether it's substantively proper or not, you don't have to worry about. Procedurally, we think it fails. And I'm not going to go through all of that again because, again, you asked Mr. Berticchio on numerous occasions, what was the emergency? You know what the answers were. We believe there was no emergency. We believe it was done to try to circumvent the court's authority. 550 days coronavirus had been around, executive orders, they throw this emergency rule in. So procedurally, we think there was no sufficient basis to circumvent what, Judge? Administrative Procedures Act, due process of notice, etc. Would take them approximately 90 to 120 days to get through that whole process of rulemaking. They skirted all of that. But substantively, this also fails because what are they trying to do? They're trying to, in this emergency rule of the Department of Health, they're trying to give authority to the school districts. And if you read the statutory citations that I give you, the Department of Public Health can only delegate its authority given to them by the legislature to the certified local health departments. You'll find no provisions that they ever can say, we're going to delegate our power to the school district or to any other administrative agency. They can't do that. So substantively, irrespective of procedure, that rule is also flawed. Another reason that it's flawed substantively, because if you read under section 3.61, they try to say what is and what is not a type of quarantine. Who interprets laws, Judge? 20 ILCS 2305, subpart C, D, and E that deal with all of these things. Who interprets those with that language? You do. They don't get to tell you what constitutes a quarantine or what doesn't constitute a quarantine. I'll get to that in the Department of Health analysis shortly. But that's what they were trying to do. They had these examples in there because if you read the rule as it existed, it said we have what defines quarantine. And then it also says modified quarantine is also a type of quarantine. And here's some examples. And again, you've read the examples. That does not mean you are precluded from determining for yourself what constitutes a quarantine. You get to decide that. But one thing's for certain, they cannot write in a rule what is or isn't a quarantine. Right? And again, thinking of the arbitrary nature of what they did, Judge, isn't it convenient that they wrote into their emergency rule what's not a quarantine just happens to try to vitiate the rulings of courts that were in place at that time. But they can't do that, Judge. And so again, this emergency rule, procedurally and substantively, it fails. As to the ISB guidance that you'll hear about, Judge, this one is as straightforward as it comes. I've given you the citation. ISB may not make policy affecting school districts that has effective rule without following the procedures of the Illinois Administrative Procedures Act, 105 ILCS 5/2-3.6. This revised and revised and revised guidance, and again, they revise it again to try to get around court rulings. It doesn't really matter as it relates to this because it doesn't have the force and effect of rule anyway because it's just merely something written by the agency. It's not adopted under Administrative Procedures Act, so it does not have the force and effect of rule that a school district can say, we're doing this because we've been empowered by this rule to do so. They can't do that with the joint guidance. I'm not going to spend a lot of time on the executive order analysis. Judge, we kind of did that with Mr. Berticchio. You can read the Illinois Emergency Management Agency Act. You can read the provisions. As I told you before, when we do statutory construction, it's specific over the general. When I read the 14 enumerated provisions and try to say, can I glean from any of them masking policies or exclusion policies? I don't get there. But again, even if somebody says they can try to extract it from that language, You go into the Department of Public Health Act, and it's crystal clear. And again, it's the lanes that Mr. Verticchio was talking about. His suggestion is that the Emergency Management Agency Act is so broad that it can disregard all other provisions of the law. Several judges have disagreed with that. I would ask you to, too. Now, as to our causes of action, Judge, as to the issue of exclusion, we've alleged it on two separate bases. Exclusion cannot be done without an order of quarantine. That's count 3. And then count 4 is you can't do it without an order of modified quarantine. The reason that I pled this in both different ways is because if the court finds that the emergency rule is procedurally invalid, then modified quarantine still exists in your eyes when it says right in there exclusion from school. So that's count 4. That doesn't mean, Judge, under count 3 that you can't find that exclusion from school is a type of quarantine irrespective of the language in the rule where they tried to strip it out. And the reason that is because the definition of quarantine, still as it exists in their emergency rule, is to separate and confine. Quarantine means to separate and confine. And if you look at the definition, in the dictionary, confine means is to restrain, and separate means an intervening space. So I would ask you, if you have a school that says, child, we're going to separate you from the rest of the children in this school, and we're restraining you from coming in this building. Is that a type of quarantine by definition? I would suggest to you that it is. Now, they're going to try to say, well, confine means you have to send the kid home. You tell them you can't leave your house. No. To separate and to restrain can be leave our school and don't come back. We're restraining you from entry. Okay? Because I would suggest to you is when they wrote exclusion from school as an example in the rule initially, that same analysis was one of the basis of which they said it's a type of quarantine in the first place. Because it already fit the definition of quarantine, they were merely elaborating upon it when they gave it as an example. And because they tried to strip the example out doesn't mean that it's not a quarantine anyway. So again, Judge, that's why we've pled it either as quarantine or modified quarantine, depending upon how you look at the emergency rule. But even if you somehow found that the emergency rule passes muster, we believe even as still written today, exclusion from school is a type of quarantine. One of the things that I think is interesting as it relates to exclusion has to do with, as Mr. Verticchio said the other day, well, they just can't go to school. That doesn't mean they can't go anywhere else. What are we trying to accomplish? If the public health is really what this is all about, really what it's about, and a child is really a potential close contact, shouldn't we as people want them to be quarantined away from everybody? If that's really the purpose? Not just merely you can't come into the school. So again, what are we trying to accomplish? Because me standing here as a citizen of this state, if we have children who are already public health risk, I don't want them going anywhere. And we have laws in place right now that can prohibit that, but you have to exercise those laws. And I understand what Ms. Haggard said, that, well, if we give everybody their procedural due process rights, the system might break. Judge, due process is not meant to be convenient. So the proposition that I'm making to you is that if public health is really what it's all about, these games that they've played with the language to try to say, oh, we're not quarantining, we're just excluding from school. To what end are you doing it? And again, if you take the time to read the September 22nd preliminary injunction order of Judge Tromper, she kind of talks about that. Because she talks about this playing with the emergency rule, going, what are we accomplishing? If public health is the goal, doesn't this emergency rule change kind of defeat public health? The answer was yes, it did. But the goal of the emergency rule wasn't try to promote public health, it was to try to cut the cord out of the conversation. Judge, as to the masking, again, we've done that. Also, is a type of modified quarantine, and also under the existing statutory provision. Because there's one thing about rules, Judge. Rules cannot change the law. You cannot create an administrative rule that contradicts statute. So as it relates to masking, again, the rule as it existed prior to the emergency change had modified quarantine as a type of device intended to limit the spread of an infectious disease. If you find the emergency rule was improper, that comes back in. That's one analysis for the court. But Judge, besides, because again, quarantine is under subpart C, 2C of the Department of Public Health Act. Under Part D, it deals with treatment, right? What is a treatment? I remember we argued this in front of Judge Schieffer, and we went back and forth for a little while, and the question was, is a mask been utilized by our state health officials as a treatment trying to limit the spread of an infectious disease? And for a long time, it was the main one, even before we had vaccinations. So certainly it's a treatment that our government's been trying to use to limit the spread of an infectious disease. And if it's a treatment, you can't, regardless of quarantine, it's a different provision of the law, you can't compel a treatment on a citizen either without giving them due process. So again, we've argued that in two separate counts as well, because again, the analysis for you will depend upon whether or not you find the appropriateness of the emergency rule. But even if you think the emergency rule is proper, which we're hoping that you don't, we still believe the statute as it exists under other provisions of the law, under subpart D, deals with the treatment option, because they can't change the law in their rules, Judge. And so again, I will sit back and I'll wait for my colleagues to respond. The law to me, Mr. Gerber and I was talking before this started, the law is pretty straightforward, right? This law is not that complicated. I understand they want to try to make it complicated, but it's not. The last thing I'll leave you with is, again, this inherent authority. School districts, do they have inherent authority to engage in public health? Not to operate their schools. Of course they do. But operating a school, Judge, you will find no provision in the Illinois School Code that gives them the ability to engage in public health. That's completely different. To create policy as it relates to public health. To create conditions precedent of what it takes for a child to be able to walk into the school. You know who does that? The legislature does that. If the legislature wants to craft something that says, you know what, during the times of an emergency as proclaimed by Governor Pritzker, during those times, you have to mask your children before they can enter that school. If the legislature does that, this case is not the same. Because they have the power to do that. They're the people. Until we have that, we deal with the laws that exist right now. I said that day before yesterday, I'm going to say it again. The legislature can do that. We've been going at this now, ma'am, for almost 2 years. Almost 2 years. And I was thinking today of how I would explain this to you. I kept going back to when I stood in the courtroom with Mr. Ferticchio in July of 2020 in Clay County, Illinois, when Judge McHaney says, well, what's to stop any of this from still going on 5 years from now? And you know what? I think he was right, because we're almost 2 years in and there's no end in sight. But you know where the end in sight is? Is the court saying that we've had enough of this. that we're going to uphold due process. I read one of the, I guess there was a case in front of you. I am not sure which one it was, but one of your quotes I just read where you were talking about this never-ending emergency, and aren't we talking about violating people's rights? Yes, that's what we're talking about right now. And I'm not asking to put anybody at risk. My clients are not asking to put anybody at risk. The legislature has what it takes. They have the power to do whatever they want within the confines of the Constitution. They can do that. Ma'am, they can do that anytime. I already know what's coming. They're going to talk about, I've heard it this morning, about if the court does this, all the grave dangers. You know what? If that's true, again, it's speculative and conjecture, but if it's true, if it's really as bad as what they say, you know what? I hope and pray that the governor convenes the General Assembly the day after you might grant this relief and says, get in there and pass a law because we need to do this to protect people. He can do that, convene them, and get in there and get it done. Is he going to do that? I hope so, because if he doesn't do that, then that means that all of this is talking about emergency. What was it? Convene the General Assembly. Let them pass a law. Let them pass a law that says, if the school district finds that a child might be a close contact, child has to go home. You know how many stories I've heard from parents over the last year and a half that they get a call from the school that says, hey, little Johnny, sorry ma'am, I use little Johnny, he has quarantine for 2 weeks. And they're like, well, why? Well, we deemed him close contact. Really? With who? Well, we can't tell you that. Well, what class? Can't tell you that either. We're like, well, he's a football player and he's going to get a scholarship and he can't play the last 2. Sorry, go home. 2 weeks, you're gone. There's nothing they can do about it. If the legislature thinks that's the right thing to do, let them pass that. But as of right now, it's not the right thing to do. It's not the right thing to do, ma'am. And that's why Mr. Gerber pointed out to you a few moments ago that there's been in this courtroom, not this one maybe, but this building, due process of law, because Mr. Wright is the one that said yes. There was hearings. Kids had to wear a mask or they were excluded from school for some amount of time because the health department came forth in this courtroom and said, we believe there's a sufficient factual basis to warrant this child may be a public health risk. Not that complicated, ma'am. That's all my clients are asking for. Now, I repeat, I understand what Ms. Haggard said, that may create a breakdown of the system. I don't know if that's true, but that's really what they're worried about. Constitution and due process, and again, this is statutory due process, does not take a break during an emergency. That's when we need it the most, and that's what we're asking you to do. I thank you, ma'am. We rest.
All right, I was going to say, who's going to go first?
I'll take the first stab, Your Honor.
Yes, please remove your mask
Yes,
so we
Your Honor.
can hear you. State your name again.
Again, William Picorni on behalf of the Chicago Board of Education, Your Honor. Just a few preliminary matters to start off with. First of all, I think it goes without saying that if the court agrees with the state defendants on their position that the governor's orders and the other actions of the state defendants are proper, there's no need to separately address the claims against the school district. So what I'll be talking about is the position of the Chicago Board of Education if the court determines that the state defendant's position is incorrect. And the Chicago Board doesn't take a position on that. That's ably defended by Mr. Verticchio and counsel for the state. We do, however, join in the arguments of the state defendants regarding the plaintiff's arguments on irreparable harm, balance of harms, and due process. Those are well stated in the state briefs, and again, I don't want to waste your time by going through what's already been stated in the briefs. I would, however, ask the court, again, as I did this morning, to take judicial notice of the fact that Chicago Public Schools are currently closed. There's 330,000 school children out of school today because the Chicago Teachers Union voted last night that they were not willing to report for work in person today and for a period of time going forward due to their concerns about the COVID-19 safety measures already being implemented by the Chicago Board of Education. Now, the board does not agree with the position of the teachers' unions, union that the schools are unsafe. We presented affidavits to you from Dr. Arwitty, the medical director of the Chicago Department of Public Health, and from Dr. Alexandra Sontag, who is the person who largely built the Chicago Public Schools contact tracing and testing program and is intimately familiar with the COVID-19 mitigation measures that are being taken within the Chicago Public Schools. And they explained to you in their affidavits that the mitigation measures that are being taken now, which include everybody in the school building wearing masks, contact tracing and identifying individuals who have been in close contact with people who are identified as positive or suspected cases of COVID-19, and excluding those individuals from the school building temporarily until they're no longer at risk of infecting others. Those measures have by and large been very successful this year. They have allowed Chicago Public Schools to stay open. They have allowed students to report to school in person and learn in person, and that is incredibly important. I think if there's something that everybody in this room agrees upon, it's that our kids need to be in school.
So the school boards adopted those measures?
Correct, Your Honor.
The school boards held a public meeting, presented the plan, had public comment, took public comment, and then adopted those measures.
The Chicago Board of Education has its own plan that was adopted at Chicago Board of Education meetings in accordance with the Open Meetings Act.
And
Yes, Your
was
Honor.
that done prior to the executive orders or after the executive orders?
I don't know specifically of the timing. I know that the order, that the Chicago plan was, it's in compliance with the executive orders. I am telling Your Honor that if Your Honor says that the executive orders are not valid, the Chicago Board of Education believes it's necessary for those measures to remain in place. And that's in part because we need teachers to show up to teach the kids in school. And the teachers have made it very clear that they're already concerned about what's happening with the Omicron variant and the rising number of cases in the city of Chicago. We need to keep these schools open, and the only way to do that is to make kids and teachers feel safe being in those school buildings. And right now, unfortunately, that's not happening. But if Your Honor enters this TRO, we can tell you that it's going to be a much harder case for the Chicago Board to make to the members of the Chicago Teachers Union to keep those buildings open.
And I'm just going to play devil's advocate here to all the school districts. And it is not meant to say it's my opinion one way or the other, but these are just questions that come into my head when I'm reading these millions of pages. And I understand that. I understand the teachers' concerns and they want to be safe. But what happens when the student leaves the school? There is nothing there saying, there's an executive order, but there's nothing mandating that they wear a mask or when they go home or where their parents have been. So this is what I'm grappling with. So
Right.
I totally get the teachers' positions. I
Yeah.
do.
I-
But there's a whole nother world outside the schools.
Completely agree with you, Your Honor, and that's why there are different realms of authority that are set up under the law. Under the Department of Public Health Act, which is what Mr. DeVore is relying on for his case, that's the role of the Chicago Department of Public Health and the other local health departments around the state and the State Department of Public Health. If an individual needs to be quarantined, in other words, isolated to their home or restricted on the conditions that they must follow in order to leave their home, that's where the Department of Public Health comes in. That's where the due process provisions under that statute come in. Schools are different, though. The school board...
I want to stop you there. I get that, and I know you have the school board. But the Illinois School Code does adopt the Illinois Administrative Procedures Act, and that's where the due process is. So how can you say that that doesn't apply to the schools? I have it here somewhere. Just let me find it. You can go ahead and talk while I'm looking.
Well...
And I don't mean to put you on.
Sure.
If you don't have the answer, someone else can talk about it.
Yeah, and I'm
just
sure
throwing this out while I think of it, okay?
I'm sure one of my colleagues is looking this up as we speak.
That's what I said.
Your Honor, the school code, and let me flip down to the section that deals specifically with this. The Illinois School Code, section 10-20.5, expressly gives school boards the authority to adopt and enforce all necessary rules for the management and government of the public schools of their district. And yes, that has to be done in compliance with the Open Meetings Act. But school boards do have the authority to adopt and enforce all necessary rules for the management and government of the public schools of their district.
Right, I know, they do.
Section 24-24 says that educators in schools, in all manner relating to the discipline in and the conduct of the schools and school children, stand in the relation of parents and guardians to the pupils. They have the right and the responsibility to protect the students in the schools, not out in the community. That's the Department of Public Health's role.
Okay.
Right? But in the schools, they have the right and the authority to make sure that people are washing their hands, to make sure, in this case, that students are wearing masks in order to protect other students from the virus particles that are coming out of their mouths as they breathe and speak in the course of their school day. 105 ILCS 5/10-20, so 10-20 of the school code, goes on to say, under powers of the school board, that the enumerated powers that are listed under the school code are not exclusive. The board may exercise all other powers not inconsistent with this act that may be requisite or proper for the maintenance, operation, and development of any school or schools under the jurisdiction of the board. So again, boards...
Right. And then finish the last sentence. The grant of powers does not release a school board from any duty imposed on it by this act or any other law.
Right, so, and the question is, what provision of the school code or what other law speaks to the authority of school boards, restricts the authority of school boards to control conduct within their own school buildings? I submit to you, Your Honor, it's not the Department of Public Health Act. There's nothing in the Department of Public Health Act that limits the ability of school boards to regulate conduct or to protect the health and safety of individuals within their school buildings. The Department of Public Health Act sets out the procedures for the Department of Public Health to follow when exercising its much broader authority that goes to individuals' ability to even leave their homes or sets conditions for individuals to leave their homes. But that's a much broader authority, and it comes with those additional due process requirements. Schools, however, have the right and the authority under the school code to set the rules in their building. And I'll also note, Your Honor, the provisions I just read off are under section 10-20 of the school code. Those pertain to school boards in general. The Chicago Board of Education has its own specific provisions of the school code that largely parallel those more general provisions. So section 3419 of the school code, for example, says the Chicago Board of Education shall, subject to the limitations of this article, establish bylaws, rules, and regulations, which shall have the force of ordinances for the proper maintenance of a uniform system of discipline for both employees and pupils and the entire management of the schools.
Did you get all that, Nancy?
I apologize if I'm talking too fast. I know you're looking now.
She's good.
And section 34-18 under powers of the board says the board shall exercise general supervision and jurisdiction over the public education and the public school system of the city, and except as otherwise provided by this article, except as otherwise specified by this article, shall have the following powers, and then it lists a number of enumerated powers.
Okay.
Then it concludes by saying the specifications of the powers herein granted are not to be construed as exclusive, but the board shall also exercise all other powers that may be requisite or proper for the maintenance and the development of a public school system, not inconsistent with the other provisions of this article or the provisions of this code, which apply to all school districts.
Okay.
Right, so, and you'll note, Your Honor, in the provision that's specific to the Chicago Board of Education, it doesn't have the same language as section 10-20. It doesn't say that this grant of powers does not release a school board from any duty imposed upon it by this act or any other law. It leaves out the or any other law part in the provision relating to the Chicago Board of Education.
Okay, that's
But
good to know.
irrespective, Your Honor, in either case, council has not identified any provision of law in Illinois that restricts school boards from requiring students to wear masks in school or to take any other COVID-19 safety precautions, from washing their hands on the way to lunch, maintaining social distancing, or any of the other precautions that school boards have in place. School boards have that, not only that power, but that responsibility to their students and staff under the school code. All right, so moving on just a bit, Your Honor.
Hold on, I'm looking at
oh,
my
sorry.
notes, if
Of
you
course,
don't
ma'am.
mind, before you move on. I have a note here, 5/24-24, talks about maintenance and discipline, because I believe that was cited in your response.
Yes.
And I noted that even that section provided for due process for the students. Isn't that what plaintiff is seeking?
No, Your Honor, that's talking about due process in connection with, well, I think that piece might talk about extracurriculars, but irrespective, that's talking about due process in connection with discipline. So I think there's a fundamental disconnect here. When Mr. DeVore uses the term due process, what he's talking about is specifically the due process under the Department of Public Health Act, where after a 48-hour period, the Department of Health has to go into the circuit court for an order of quarantine, right?
Yes.
Due process in the school discipline context is an entirely different question.
Okay.
Right, and it doesn't require a court hearing in the vast majority of, I mean, it doesn't require any evidentiary hearing in the vast majority of cases, right? Principal sees a kid running down the hall, tells the kid to stop,
Right.
and either the kid stops or he explains to the principal, I'm running because there's an emergency and I need help, and that's the due process that, under that circumstance. Right, it does not, Mr. DeVore is saying that the provisions of the Department of Public Health Act preclude the school from adopting rules to begin with. That's not what the law says. The law says that within schools, the legislative body that has authority to adopt rules for that venue, for that setting for students, that is the Board of Education. The Board of Education is empowered to adopt those rules. So, for example, you know, the Board of Education adopts a policy that says, yeah, we want all teachers, before they bring their kids down to the lunchroom, to have their kids wash their hands for good sanitation reasons, and, you know, perhaps because of COVID-19 or other, you know, infectious diseases. It could have happened before this pandemic, and certainly more school districts are adopting policies like that now. Mr. DeVore's position is that the school board couldn't adopt that because that's a provision to you know, control and affect infectious disease. That's the exclusive province of the Department of Public Health. That's not how it works, Your Honor. The school board has the authority to adopt the rules that are going to govern what the conduct is in the classrooms in that school. Just as Your Honor, for example, has authority to direct people to comply with this court's standing orders regarding wearing masks in the building. I'm not entitled to a hearing to challenge that general order prior to complying with an instruction from yourself or one of the deputies to comply with this court's order. It's the same thing with respect to school boards. Now, when boards adopt those rules, yes, again, there's process that they have to follow to do that. That's the Open Meetings Act. But there's no allegation in this case that the boards have not followed those policies and procedures and validly adopted the rules that are in place in each of those districts. That's not the case.
There's a specific allegation, but isn't that what he's saying when they're, I don't think he's 100% disputing the authority of the school boards. And that is something that has to be done independently. But isn't that the due process that you're doing with the Open Meetings Act and all that?
Well,
to have public comment from the parents to see what they want?
Exactly, Your Honor. And you know, to the extent that that's Mr. DeVore's position, I don't understand that to be what he's saying. I understand him to be saying, look, I don't care whether they went through an open meeting or not. They don't have the authority to do this unless the General Assembly specifically says they do. But that's not what the school code says. School code says, yeah, they have this unless we've said they don't, and they haven't said they don't. That's the school board's position. And Your Honor, if I...
So you're saying that the Chicago Public Schools, that you do your own contact tracing, you do your own investigations. You have that own independent authority. Let's say the Illinois Department of Public Health didn't even exist. You have that authority under the school code.
Under the school code, yes, within the school building. Now, again, not in the community.
Right, no, just
But
in the school.
within the school building. And we've provided in the affidavits evidence that these policies are longstanding. These are not things that were invented with respect to this pandemic.
Okay.
Right? So Dr. Sontag explains that the Chicago Board of Education has long had a policy on the control of infectious diseases within its schools. It's long had a policy saying that delegating the authority of the Board of Education to the CEO of the Chicago Public Schools to exclude staff and students from school in order to control infectious diseases. Now, previously, it's never been on anything like the scale that we're dealing with in this pandemic. We're talking about isolated outbreaks of measles, right?
Right.
And Dr. Sontag, I believe, testifies in her affidavit about, in her time with CPS, there have maybe been 2 or 3 cases. So it's a completely different scale. But it's not fundamentally different in the policy that's being applied or the authority of the board that's being applied here. And we also make the point in our brief, Your Honor, that to the extent that, look, Mr. DeVore didn't talk at all about any of the elements that he needs to show to prevail on a motion for temporary restraining order. He's got to meet all 5 of those elements, Your Honor, as you well know. But even before we get there, one of the core purposes of a temporary restraining order is to preserve the status quo so that the court can proceed to address the merits of the case and prevent irreparable harm from occurring in the meantime. The status quo in this case is the long-standing policies of the Board of Education regarding infection control. Right, those have been in place. We presented the version of the policy that was in place in 2017, but we could go back further and show that this policy has been in place for years, probably decades.
But in that policy, did you have on there that the students had to wear masks?
That policy doesn't address masks, but the mask policy was in effect, Your Honor, last year when students were in the school building.
Okay.
All right, again, so this is a long-standing policy of the Board of Education that, we have the ability to require students to wear masks in school in order to protect them from infectious diseases. Right? And school, we presented documentation showing all the different procedures that the school follows when a student has, I've got a stomach ache. Okay, here's what the school does, and it's not limited to COVID-19. Okay. But the schools are there standing in the relation of the parent to the students in their building, and they have the right and responsibility to take care of those students, separate and apart from the responsibility of the Department of Public Health to take care of the broader community. And that's the right and responsibility that we're talking about here, through the process and authority of the local school boards around the state. Okay. Now, Your Honor, I'd also like to touch on the question that I think is really important for this court, and that is the balance of harms. Now, I know Mr. DeVore has said he wants this hearing to be about the law. He doesn't want to get into the facts about the COVID-19 pandemic, and he questions whether is it really still an emergency and all that. But Your Honor has to rule based on the evidence in the record.
Right.
Right now, you have affidavits from public health officials telling you that if Your Honor enters a TRO in this case, and schools are no longer able to require students to wear masks in schools, they're no longer able to exclude students who are identified as close contacts of people who have COVID-19. You are going to, number one, increase the spread of COVID-19 in schools, which will have negative health effects on the people immediately present. And you're also going to make it much harder for local school districts to keep their schools open. Again, that's exactly what we're seeing for all 330,000 children in the city of Chicago, enrolled in Chicago public schools today.
But that's not what Mr. DeVore is seeking. He's not saying they don't have to wear masks. He's saying just give them due process. I hear that over and over, and I know that's what it is.
Right. So,
and I hear from everyone, we want them to wear masks. He's not saying you don't have to wear masks.
Sure. Let's talk. What does that?
Let's talk about that.
Yeah. What does due process mean in the context of wearing a mask? So, Department of Public Health can identify somebody who has or they believe has COVID-19, and they can present evidence to a court that they are infected and at risk of spreading that infection to others.
Right.
That's terrific. If we know that person has been tested or they have symptoms of COVID-19 and can present that evidence. Clear and convincing evidence,
right,
according to the standard in the Department of Public Health Act. And that's high for a reason, because it is a significant imposition on somebody's freedom to say you can't leave your house until the Department of Public Health says you can.
Right.
For obvious reasons. So, but that is not possible when we're talking about masks, because the affidavits that have been presented to you explain masks are there for those of us, not those of us who look or feel sick. By the time you feel sick, you should be staying at home anyway, right? If anybody in this room has symptoms, they shouldn't be here to begin with. But we're still wearing masks. Why is that? Because COVID-19 is often asymptomatic and can be spread by people who you would never know have that illness. Right? There's no way to screen everybody in this room, without requiring everybody to present a test, which presents its own logistical problems, right? So, and I'm sure would bring challenges just the sort that we're addressing here in Your Honor's courtroom today, right? So we take the precaution of requiring everybody, even if they seem to be healthy, to wear a mask. It's not a treatment for somebody who has a disease. It's no different than washing your hands. I don't wash my hands because I think I'm sick. I wash my hands because I don't want to get sick, and I don't want to, put my hands on the elevator button or on the doorknob and make somebody else sick by passing that disease to somebody else. So to say that, well, just go get a quarantine order and make somebody wear, what are we going to go get a quarantine order for 330,000 school kids in Chicago or 900,000 kids around the state?
Well, that's what Mr. DeVore is arguing.
And that's exactly why Your Honor.
It's just due process. Well, again, I'm just playing devil's advocate.
Right, but
if they don't like it, then talk to your legislator.
Well,
have
but
them
they
change
did.
the law.
But
Because they changed other aspects of the law all during COVID. Or why doesn't the governor suspend that portion of the statute? He suspended other portions of the statute.
Sure. And
I know you can't answer that, but
right.
I'm just throwing this out there.
Yeah, and I hear you, Your Honor. Those are arguments for the state.
Right.
But when you say talk to the legislature.
There you go, Mr. Verticchio.
Yeah, thanks, Bill.
When you say talk to the legislature, Your Honor, again, the school code says in the school building, the school board is the legislature. That's why we have school board meetings. That's why people are showing up to these school board meetings, to voice their opinions to their school boards, to be heard by these board members and considered, and have the board members, adopt their feedback in the rules that are adopted in each school building.
Okay.
So that's the process that's due when we're setting the rule.
Right.
When a teacher tells a kid, wash your hands before you go to school, the kid isn't entitled to a due process, or not before you go to school, before you go to lunch.
Right.
You don't get a due process hearing before that. If you're going to suspend a kid or expel a kid because he's refusing, that's maybe a different question, but that's not the case that's being presented here by Mr. DeVore.
Well, I think that's what he's asking. If they don't want to wear a mask, then give him his due process. Am I incorrect?
I think you're
send them out the door, Judge, if they don't wear one.
Well, if that's the argument, that they can be sent out the door, if a student who refuses to wear a mask can simply be sent out the door or disciplined for refusing to comply with the district's duly adopted policy, then that's fine, but then Your Honor shouldn't enter the TRO because that's what's happening now. Right?
So you're giving them a choice whether to wear a mask, and if they're not, then you're giving them due process.
Absolutely. Nobody is going to be disciplined if they simply put their mask on when they're asked to. Right?
But what if they don't put their mask on?
And if they don't put their mask on, they can't be in the school building until they're willing to put their mask on. Right? It's just like, a kid shows up to school without appropriate attire. They're not allowed in the school building until they comply with the district's duly adopted policy.
Okay.
Right? And the district has that authority. The board has the authority to adopt those policies for each school. Let's talk a little bit about irreparable harm, Your Honor, because this is another issue.
Can I ask you a question before
absolutely.
we get to that? Because I have my note here. So, the Illinois Department of Public Health did not implement emergency rules requiring face coverings or vaccines. We're not here on vaccines. So what is your authority to require the students to wear a face mask? Am I understanding you correctly? It's your independent authority through the school board
Yes.
to implement these measures to
Yes, Your
require them to do that.
That is the Chicago Board of Education's position, and I think the position of all the other school districts. I won't speak for them, but I think that's the position they've taken.
Okay.
All right, may I talk about irreparable harm, Your Honor?
I want to ask you, because, I'm sorry, I did read your motion, I have notes here. You say there's no legal authority whatsoever that masks constitute a treatment. So what about the authority that the FDA has regulated it as a medical device? That was my note to ask you.
Right, I don't know about the FDA's authority, and I'm not sure that's an argument counsel has raised, but regardless, I think if you look at the regulations from the Department of Public Health, and again, Mr. Verticchio can probably shed additional light on this, but masks are more, they're not on the order of a treatment in the sense of, something that you administer, that a health professional administers to an individual who already has a diagnosed condition or is suspected to have a condition. There's something that you use for healthy people in order to keep them healthy, and if they happen not to be healthy because you can't tell who has this disease and doesn't, to keep them from inadvertently spreading it to other people. It's not a treatment, and the fact that the FDA regulates something or doesn't, I'm not sure, to be quite honest, Your Honor, what the standards are for the FDA to have authority to regulate a device or not. I don't think that argument has been presented before this court, but I don't think it has any bearing on what state law is or what school board authority is under the school code in the state of Illinois.
Okay.
And I will add, Your Honor, that even if the Department of Public Health has authority to administer treatments, and even if, Your Honor, finds that that masks are a treatment under the Department of Public Health Act, and therefore, when required by the Department of Public Health, have to go through those due process procedures, that doesn't mean that when students are required to do that in the context of a school building, that as a condition of being in the school building, that those same provisions under the Department of Public Health Act apply. Because again, the school code says the school board has authority to adopt any rules not inconsistent with the rest of the law. There's nothing inconsistent with saying that there's two different bodies here who have differing levels of authority. School boards control what's happening within the school building, but not outside it. Department of Public Health has a whole broader range of authorities, but also more procedural restrictions. Two completely different grants of authority under the law, and they do not conflict.
Then I have here, the Chicago Public Schools relies upon the emergency rules to say that exclusion from school does not constitute confinement. And we had hours of argument on that on Monday.
Right.
Were you here?
I was here, Your Honor.
Sorry, but.
Yes.
And I just didn't know if you had a short opinion that the rules were rightfully promulgated.
We're not taking a position on whether or not the rules were correctly promulgated.
Okay.
Our position is that to the extent that plaintiff is going to rely on rules that were adopted by the Department of Public Health to say that school boards don't have the authority that the school code seems to say they have, right? He can't have it both ways. He can't rely on the rules in one respect and then say you have to ignore the rules in another. If you're deferring to the agency, you defer to the agency, and that should be the case either way. But in this case, I think our position is simply, we don't really care what the Department of Public Health says about the definitions under the Department of Public Health Act, because that has nothing to do with school boards.
Okay.
There's nothing in the Department of Public Health Act that says that the Department of Public Health has plenary authority to set rules relating to public health within schools, or that local school boards don't have that authority. In fact, the statute says exactly the opposite, because there's not an express provision to the contrary.
Okay.
And I'll note that that's one of the arguments that Mr. DeVore was making on Monday, which, again, we didn't have a chance to stand up and address this, but it's pertinent here as well for this case. Mr. DeVore was pointing to, for example, the provisions relating to the control of chronic disease in the school code. And yeah, there is a specific provision about control of chronic diseases in the school code. But the school code says, the General Assembly says in the school code, look, just because we say that the school board has a specific grant of authority doesn't mean it doesn't have other authorities. So this idea that by specifying one authority that necessarily implies that a board doesn't have other related authorities that the General Assembly didn't exclude in those express grants, that argument can't apply because the General Assembly specifically said in the school code it doesn't.
Okay. Now you can go on.
All right. Thank you, Your Honor.
So what were we on? Balancing of harms.
Right. So let's talk about the balancing of harms here,
Okay.
Your Honor. Look, I understand Mr. DeVore's point about due process. Due process is important in our system of law, but it's also not, an unlimited grant, and it doesn't say that everybody's entitled to an individualized hearing before they have to follow any rule that a body that's empowered to create those rules lays down, right? So, but beyond that, even regardless, the issues of the merits and whether the plaintiffs have a due process right or don't they is independent from the question of whether the plaintiffs are being harmed by this supposed violation of their rights. There is nothing in the record Your Honor, that says that any of the individual plaintiffs or their students have been harmed by having to wear masks at school. The harm that Mr. DeVore identifies in his motion is simply that students fear they will be disciplined if they do not comply with those rules. Well, it's the same answer to a student who fears he's going to be harmed because he wants to run down the hall and the principal won't let him. Don't run down the hall. All right? And there's no fear of discipline if the rules are being complied with. Mr. DeVore has to show not only that there's a due process violation here, but that students are actually losing something or being harmed in some way. They're being deprived of a property, liberty, life interest.
I suspect he's going to say they're being deprived of due process.
Right, but due process...
So we'll just cut to the chase.
Right, but due process exists to protect something.
Right.
The question is, what is it there to protect? Right? There's no inherent right to be present in a school building without a mask on. Nothing in the Constitution, nothing in the statutes of the state of Illinois. School districts have the right to set rules for what happens in their school buildings. So there's no inherent right there that students are being deprived of. Now, recently, just yesterday, Mr. DeVore presented this affidavit from Dr. Stock who talks about medical harms that some students supposedly experience as a result of wearing masks. Now, Your Honors granted us leave within 7 days to file a responsive affidavit, and we intend to do that, addressing some of these issues that were raised by Dr. Stock. But I can tell you, looking at that affidavit, we'd invite the court to scrutinize that compared with the affidavits that have been presented by Chicago Public Schools and by the state. Dr. Stock's CV indicates that he's a medical doctor, but there's no indication that he's board certified in any particular relevant specialty, that he has any particular expertise in public health and immunology, any of the issues that are being dealt with by public health experts, including the experts that we've presented testimony from today. His primary claim to fame, if you Google Dr. Stock, is a viral video of comments that he made to a school board in Indiana. It's been widely picked up in the media, and he was widely criticized for spreading misinformation about COVID-19, including claiming that the COVID-19 vaccination was actually causing the Delta surge as opposed to the virus itself. Okay. Right. So, there are issues with Dr. Stock as a competent expert in this case, but more importantly, if you drill down and look at what he says, he's providing his opinion on the effects of masks, but he's not citing any data or offering any explanation for the basis for his opinions. And it's worth noting that the opinions he's offering are contrary to the great weight of scientific and medical opinion regarding the importance of masking, including the CDC, the Illinois Department of Public Health, Chicago Department of Public Health. Every level of public health experts in this country have said, yeah, kids should be wearing masks. Everybody in schools should be wearing masks. So, extraordinary claims require extraordinary evidence, and the affidavit of a single doctor who has no evident expertise and cites no data or studies to back up his position is not an appropriate basis for this court to conclude that kids are suffering any harm. But even if the court were to give credence to Dr. Stock's affidavit, the fact is that none of Mr. DeVore's plaintiffs have actually alleged that their students suffered any harm as a result of wearing masks in school. So if these effects were true, it's kind of surprising that those allegations aren't present, but at the very least they're not in the record for purposes of these TRO motions. Right, so there's no showing of actual harm from students wearing masks or being required to wear masks in school.
Okay.
I'd say the same with respect to exclusion of students from school. There's no allegation, I don't believe, that any of the plaintiff students actually have been excluded or particularly likely to be excluded from school as close contacts any more than anybody else. So that harm is entirely speculative. What's more, Mr. DeVore told a story about little Johnny not getting to play on the football team because he had to be excluded from school for a period of 2 weeks because he was a close contact. Well, I understand that that's a story that Mr. DeVore would like the court to consider, but that evidence isn't in the record. Okay. And the court can only proceed based on the evidence that plaintiffs have presented. They haven't presented any evidence of actual harm yet. In contrast, though, Your Honor, the defendants have presented evidence of actual harm that will occur if the court grants this injunction. Again, I don't want to belabor the points we've already made, but we have medical evidence in the record that schools are open to the, well, Chicago public schools are not open today, but granting the TRO is not going to help that situation. Right?
Fair.
But up until today, schools have been able to be open this year because of these mitigation measures. Right? That's what allows kids to be in school. Right? And so to the extent that being excluded from school is harmful to children, and we've presented evidence from Dr. Sontag about the effect that school closures have on children and society as a whole. It is not good. What our society has been through in the last couple of years has been traumatic for our kids and for all of us, Your Honor. And so everybody in this room, I think, wants our kids as much as possible to be there in school, learning in person. I know I want that for my kids. I think, I hope everybody agrees with at least that basic premise. And the way to ensure that that happens for the most kids is to allow schools to continue the mitigation measures that they have in place. And, I'll just note, Your Honor, that even if Your Honor agrees with Mr. DeVore, even if you think that he has shown the other elements necessary for him to receive a TRO in this case, the appellate court held in the JBL Properties case that the balance of harms issues is dispositive. So if you conclude that granting this injunction would be more harmful than beneficial, the harm to the public good would be greater than the harm to the plaintiffs of not granting the injunction, you have to deny the TRO, even if you think the case has merit. So unless Your Honor has any further questions, I'll yield the floor to my many, many colleagues here.
Just let me look at my notes. Just to let you know, I still have emails popping up. I'm on my page here. So I have a note here to discuss with you, but I think I understand it from your arguments now, that Executive Order 24 that was issued on the 17th, it clarified the school's authority to exclude students from school, all the stuff that we have talked about. This fundamentally, it changed the law that has been in existence since 2014, and it transfers the local health department's responsibilities to the schools. And I think I asked you this, and I don't know if you can answer that. So prior to these amendments, if anyone refused to do what was said, they were subject to, the due process. And now that they are automatically excluded, the government has set up a situation where if you don't follow the rules, then you are punished. You're saying that you don't have to do that at all through the Illinois Department of Public Health. Like I said, you guys don't even have to look at that, even though the school code adopts the Illinois Department of Public Health due process. You're saying, let's not even look at that, I'm going to put a blinder on. Let's just look at the school code and what the school boards can do, just general. Am I understanding your position?
I would offer a friendly amendment to what I think Your Honor is saying, and that we're not saying that the school code adopts the Department of Public Health Act. We're saying that, as Your Honor said, school boards have independent authority.
I said that wrong. I meant the Illinois Procedures Act. I'm sorry. Go ahead. I didn't mean to interrupt you.
Right. I mean, the school boards have to follow the Open Meetings Act. I don't know that they have to follow the Administrative Procedures Act. But right, the State Board of Education does. But that's different than local school boards, Your Honor.
Well, I'm looking, I have here in the as cited in the school code. Health, I'm just looking under one provision, okay? And this is, and I know someone cited this to me on Monday, health examinations. That's 5/27-8.1, health examinations. And it's
Yes.
long, it goes through all kinds of things. And yes, you require them to have this before coming into school and all that. But it also says here at the end, the local school authority shall inform the parent or legal guardian of exclusion procedures in accordance with the Department of Rules under Part 690 of Title 77 of the Illinois Administrative Code. And then if you go to that, and I think it's section 1330, that's where the due process is outlined. So I don't understand how, I get it, I get the school board part, and I don't disagree with you on that, I'm gonna look into that more. But how can you ignore that, where this circulates back to the Illinois Administrative Code, where their
Right.
due process rights are outlined?
So I think this is explained in the affidavit from Dr. Sontag, Your Honor.
Okay.
When Chicago Public Schools does its contact tracing in schools, there's two related but separate things going on. On the one hand, they have to do the contact tracing because, frankly, they have access to all the records, the contact information, they know where the kids are, they know who they've been in contact with because they have the class schedules and know all the teachers, right? So that has to happen within the public schools. They partner with the Department of Public Health to provide that information regarding those procedures on quarantine, which is a separate procedure, right? So what the school board says is, look, you're excluded from school, but the procedure under the Department of Public Health Act relates to quarantine and isolation more broadly.
For
Two different
infectious
things.
diseases, right?
Right.
So then go back to Mr. DeVore's argument, what if they don't have it, and how do they know that? I mean, it's just all circular.
Well, and I mean, just from a practical perspective, Your Honor, that's the problem with COVID-19. You don't know if somebody's going to get it until you go through that quarantine period and see if they develop it. That's why we have to do this, Your Honor, from a practical perspective.
Even if they don't have any symptoms or anything?
Yeah, that's what
Without having due process, you can exclude them from school?
That's what the science says we need to do, Your Honor, because otherwise you've got somebody who's potentially spreading this disease in the school. They may feel perfectly fine, but they're giving it to 3 or 4 others, and all of a sudden you've got a cluster, right? And that's what these rules are designed to prevent.
I get that.
That's why we need to do it.
But then it goes back again to my question, well, what happens once they leave the school grounds?
Well, and again, that's,
You know?
that's the Department of Health's issue.
Okay.
They're in contact with the families. Then if the family refuses to stay at home and comply with quarantine,
Then they come to
then they
court.
go to court, right?
Okay.
That's what that process is for, but two
Okay.
separate and distinct things.
Okay, that's fair.
Thank you, Your Honor.
I'll give a brief response. That was a lot, Judge.
Yes.
I will take it. Your Honor, the first thing I was going to say, it's funny, my phone just popped up, and our esteemed colleague, Mr. Zeebel, says better than I. Is it really the Chicago public school system?
Your Honor,
It's my position.
we're taking notes from somebody over a phone? I object to that. Is this person, has he appeared in this courtroom?
Yes.
What's,
It's Lance Zeebel, right?
Yeah,
Yeah.
he's in this case.
he's not in this case. He's not in the Austin case.
You know, I'll just say it. What, Tom?
He's in the main case
Don't
that
we have
this all
enough
went
names in
into,
here?
I think.
I was going to say it, and I'm just making it irony that it pops up because Will said the same thing. Is the Chicago public school system suggesting that the school code preempts the Department of Public Health Act? Because that's what I heard. I got it written down here in big notes, and Will tapped me on the shoulder, said the same thing. Because that's a new one. The Department of Public Health Act is preempted. The supreme authority on these issues is preempted by general provisions of the school code.
Is that
And
what
you
you're
kept
saying?
talking about this.
Just, I'm gonna stop you right there. Is that what you're saying?
No, Your Honor,
Counsel here is shaking her head, yes.
there's two.
Let him say it, Judge. I want him to say it.
They're two different things, Your Honor. So the Department of Public Health has, yes, if the Department of Public Health says somebody has to quarantine and the school board says, oh, no, you don't, Department of Public Health wins. There's the supreme authority. But the school board still has the inherent authority to control what happens in their building. That's our position, Your Honor.
I don't know what that means, but let's look at the Department of Public Health Title 77, 690, Judge, which lays out all of this. Go to provision 690.30, where it specifically talks about schools, under Part C, Ms. Satterley and I have talked about this quite a bit, and it talks about schools, child care facilities, and colleges and universities. Persons suspected of being infected with a reportable infectious disease for which isolation is required. Isolation, if it's required, gets due process. Shall be refused admittance to the school while acute symptoms are present. Judge, that provision of the rule right there completely contradicts what my colleague just said. Because if they can do what they want, why is that written in the rules right there? So I'm not so sure that the Illinois Department of Health agrees with them. But I guess that's a conversation for a different day. And we'll be interested to find out if Mr. Verticchio, on behalf of the state, believes that these school districts can do what they want, irrespective of the state. Because if that was really true, the state superintendent wouldn't be threatening recognition status of all these school districts who thought differently than the Chicago public school system. Because when they were creating policy of mask optional, here come the state down on them. If they have this inherent authority to do what they want, then why is the state threatening them? But again, you can read that provision right there, which completely contradicts it. There is no way that they can say we can do whatever we want inside the school building and we can disregard the due process. We're not talking about washing hands. We're talking about matters that we're arguing to you fall with under due process. Quarantine. Excluding them from school. You can't have your education. Get out of here because you're not doing what we say. Judge, that's completely different than washing your hands and things of that nature. Irreparable harm, if you find that due process under the law is required, that's irreparable. This is not about masking, whether a kid wears a mask or not. It's whether or not they're being entitled to due process. That is a right to them. And if you find that's being violated, irreparability automatically happens, Judge. Balancing of the harms. Again, they want to make this, we talked about this over lunch a lot, they want to make this about these practical issues. And they want to talk about the doctors and, Dr. Beesdale, I've seen her CV. It's very impressive. The best the taxpayers' money the state of Illinois can buy, it looks like. That's not about this, Judge. They're talking about, and you even said it at least as it related to Ms. Haggard, that those harms that they were saying would occur if the court granted this relief, you said it was speculative. I understand that. But you're balancing that against what? This potential harm that, again, could be remedied by the legislature like that, but this potential harm if you grant the injunction against what? Against people's due process, which is a bedrock principle of this nation, in this country, in this state, being taken away. Balancing that harm, that's a pretty bad thing, because Supreme Court Justice said in Steele cases that even if lives are at risk, we don't throw that in the trash, because if we get rid of that, we have nothing. So I would even suggest to you, Judge, even when you balance the harms, you're balancing the loss of due process against what they say is going to happen. And I understand, my colleagues, the practical, especially the Chicago public school system. It's the biggest system in our state by far, third, I think, biggest in the nation. I understand the practicalities they deal with. I really do. I mean, as this gentleman just said, their teachers' unions already said, we're not coming to school. Okay, that's tough. I understand that, and I sympathize with that. But to say we're going to disregard the law because of the politics of the school system, that's not the answer, Judge. It's not the answer. And for preserving the status quo, and they talk about that, Judge, I've cited it to you. When the harm is the status quo, and that's what we have here, it's not about preserving what's in place, because what's in place is the harm. That's what's the harm, Judge. And so again, the general propositions that they cite, these general provisions of the school code, they all talk about the maintenance and operation and management of the schools. They want to say that that's so broad that it covers matters of public health. And you brought it up many times, Judge. You're like, well, wait a second, if public health is the issue, what happens when they leave the school? And they try to say, well, that's not for us. That's because this is not an issue about schools. If it's really about public health, it's about everybody, all the time, in the school, outside of the school. That's why the Department of Public Health manages these issues. That's why they manage those issues. And again, I agree practically with my colleague as well. You know, how does the health department do that? How do they deal with that? The answer is, Judge, I didn't write the law. I didn't write it. And if I was in charge and I was truly convinced of the harms that all of my colleagues are giving, and I'm not saying if I listened to everything they had written down, that I wouldn't raise those concerns myself. But I would be standing in front of the legislature saying, you got to do something. Governor Pritzker's a powerful man. You saw the picture of him probably sitting in London, chumming it up with the Speaker of the House and the Senate leader, without masks on, of course. Bring him to session. Bring him to session. They got a supermajority. Fix it. But the fix can't be, we're going to disregard the due process that's there. Again, there's nothing to suggest that the school code, they can do these things in a vacuum, Judge. None whatsoever.
Sorry, Rob.
Yeah, no one else is talking except council if you have any rebuttal, and then we're going to take a 5-minute break. Then you can talk.
Actually, I would like to turn the floor to my colleague, Ms. Baser, who has an answer to one of the questions that you asked earlier.
And I'm sorry, you need to remove your mask, and you need to tell us your name.
Sure, Nikki Baser, B-A-Z-E-R. I just wanted to address the question you raised about 27-8.1. I think what the section that you're talking about is that if someone has a religious exemption to vaccine and there is an outbreak of the disease that they are not vaccinated against, then the school district is obligated to exclude that student from the school building until the outbreak is over, until such time as the child is vaccinated. And so the reference there is to just that process of informing the parents that the child will be excluded in the event of an outbreak of that disease. So just wanted to clarify that for you, Your Honor.
Thank you. All right.
And, Your Honor, just one other point,
Yes.
and I'll keep it very short. I think council has, in conceding the practical difficulties that the health departments are going to encounter, that the Chicago Public Schools will encounter in keeping schools open, council has just conceded the issue of balance of harms, Your Honor. This court has to look at the harm that will result to the public if the injunction is granted, compared to the harms that are going to be suffered by the plaintiff class if it's not. And closing schools down, sickness, unnecessary illness, those harms vastly outweigh. I mean, I understand the legal rights at issue, but this court has to take that in consideration, as did the court in JBL Properties. That was dealing with the eviction moratorium. The landlords in that case certainly had legal rights that were at stake, but the court nevertheless found that the harm to the public of lifting the eviction moratorium during a pandemic would vastly outweigh any benefit of the TRO. So I think in this case, the same analysis applies.
But then that again brings me back to all circular.
Do it, Judge.
Are we still in an emergency? We're in a different phase than we were with JL Properties. That was, the beginning of COVID. Look where we are now. And you don't have to answer that, but this is just stuff that goes through my head.
Yeah, and I mean, all I can say, Your Honor, is, I know Your Honor reads the newspapers. You're aware of what's happening. Rising cases, hospitals canceling elective surgeries, the teachers in Chicago. So yeah, it's a different phase, but I wish I could say it was over, and it's not.
No. Okay.
Judge, I have answers to some of this. They're going to take a lot more than 5 minutes.
Okay, and we're going to take a break.
Thank
Because
you, Your
we've been
Honor.
in here for an hour and a half, so I want to take a break, and then we'll come back in and start up again. Okay?
Thank you, Your Honor.
Thank you.
Yes, sir. Well done, sir. Thank you. Very impressive.
All offer you is here. I'll offer you.
Yeah, no, I know, I did the same thing. Yeah, I know,
Additional health exams in both physical and for credit. We can get a rate and that was about it. That's why I build it. Necessary by both the ultimate decision is discretion.
even if that section applies.
It's expressed. Right. It's expressed. To the extent that there is a cooperative dance between public health and school boards have their role.
Yeah, I agree. Yeah. Please, I got. Yeah.
We're not in school, we're not in legislature says
Been delegated to us. We'll probably get that one. That one's already up at least. I'm good. How are you? I'm good. How are the babies? Well, he's good. I just have to. Oh, I wanted to. He's probably going to college already. He started school yesterday. No way. Yes. Oh my. Like just a little like extra, 2 hours a day. But that means he's 3. He'll be 3 at the end of the month. Okay. So they let him start because he turns 3 before the end of the month. Oh, okay. Yeah. So. Yeah. So it's crazy, isn't it? Oh, it is. I had to keep my mouth shut to some of the questions she asked about CPS and before I don't answer that. I don't know the answer to that one. How's private practice? Oh, it's okay. It's where I started. Yeah. Back then it was Trevor Silverstone. Oh, I didn't know that. Yeah, I was there for 7 years. Then I went to CPS. So you were at CPS for like a lifetime? Yeah, 26.5 years. Yeah. And I left it alone. Wisconsin? Yeah, that's right. I don't want to get I get it. It's hard. It gets hard when your head gets longer. Believe me. Oh my God, we've done this 27 times. I know. It's not going to work. Yeah, I know. I was like, I knew that was what I would be marching into. Oh yeah. So. Actually, I was talking about you the other day about something about the general assembly and legislature. One of the things I was most impressed about was Jones Secretary School, the Code for Red Festival was just being so nasty. She would just slam and swing and too cool. Because I'm like, I have to sometimes on the channel that I don't do that. I got on the train that day. It was the only time in my 2 whatever years at ISB that I got on the train and went out the hall before I got on the train. That period was the only time. Well, that was amazing. And it was like, that was reflecting. Oh, that was terrible. Yeah. That was one of the most awful things. Yeah. And so then, like when they started taking us, we didn't get it anywhere like you did. No. You held it cool. It was so good. Yeah. I don't know how I do it, but I can manage to not get nervous in those situations, and I can manage to just stay even. See, I think it's a defense mechanism. Yeah, I'm not like nervous, but I do have a tendency to bow out. Well, or to, when they raise their voice, I raise, and I really try. And after I saw you do that, I'm like, it's just so much more effective to do that. Not match them voice for voice or snark for snark. Yeah. Yeah, if you get combative, it just goes on. One of the first times they threw me in front of a legislative committee, I think Sarah and Amanda usually figure out who to throw in there. It was on. it was on data privacy or something, but I knew nothing about it. But they just needed some shit. Yeah. And the management associations got massacred in the first part. And I was able to keep my thumb on this, and I was like, "Will you guys just figure it out?" No, really. So much nicer. Are you for me? You know, if I could have, I'm happy with it. If I could have, my perfect job was the job that I had with Tommy Power Guys. And he was a great boss and so, that was a great job. Yeah. And I will go back to that extra long for you. Yeah.
It was good. All this was like broken and I like realized that's like I should.
We have a bunch of great people. We have a bunch of great people. Building like the new place. Trying the new stuff. Yeah, go to that. Business and, you know. How many did you go on? Yeah. She go to 20. Okay, yeah. 30. She said that Fort Worth closes at 49. Oh. Okay. Good to know. So we're not going to be here till 10 o'clock at night, are you? Too early?
I mean, we could be, but don't you? You might take a shot too.
I'll go back over to the other side because there wasn't room on this side for you. There's 7. Okay. So.
I got it. Thank you. Not a blowing fire. Thanks, Mallory.
Because the general, the most frequent.
Oh, you have the 05 kids? Yeah.
Instead of taking her up on her offer.
Yeah, right.
Yeah, I know you guys are the first one. My area.
At least get that part.
All right.
So pleased the principal and the running came out. I'm like, oh.
Had to work at it.
Yeah. I love that. Whatever you left it for them. I'm usually the last stop, but yes.
That's right, I love it.
And you were on that line. I remember that meeting. My husband got the job as Mike's CSPO, so. I was in this way, so, yeah.
Get hit with like a heat wave when you walk in here. Thank you, have a seat. Before you talk, I'm going to direct this at you or anyone else who might want to talk in the future. I'm sorry, Nancy, were you ready?
Yes.
Okay. Your argument that the school board has such independent authority, if they have such independent authority, why did the governor then mandate that the schools comply with IDPH and ISBE with their joint guidance?
Well, I can't,
Joint guidance.
I don't presume to speak for the governor, Your Honor, that's Mr. Verticchio's department, but
Right, but
my understanding is school
but you're
boards
talking
were,
about the independent authority.
right, school boards were exercising their independent authority in different ways, and the governor apparently made a determination that statewide we need to set a single standard, and that's what the state did. Again, whether the governor had the authority to do that, that's for the state defendants to discuss with Your Honor. Our point is only that in the absence of the actions that the state defendants took, the local school boards have the authority to take actions on their own behalf.
So if you can force them to wear a mask, can you force them to do other things, you know, something
Well,
that they don't agree with?
I mean, that's kind of what happens in schools, Your Honor. Our kids have to do all sorts of things they don't want to do. And schools have all kinds of rules that kids, they can't carry certain kinds of backpacks.
Right.
They have to put their coat in their locker. They can't, wear
But
hats.
that's not in the same realm as this. I know
Well,
that.
I submit, Your Honor, all those things are to protect the health and safety of the students. They're all of a piece, right? These are all part of the responsibility of the school board to provide for good order in the schools, protect health and safety in the schools, and make sure that school can run in an orderly fashion. Infectious disease, unfortunately, is a reality in our society right now, and it's something school boards they can't just close their eyes to it. They have to take action on this, just like they do on other safety issues in schools.
Judge, you might want to inquire if they believe then they have the inherent authority to require vaccinations of children. I wonder if they think they have that.
I mean, that's a whole nother can of worms, but
Same
yeah.
Right, it is, Your Honor, and I don't know that, I can't take a position for the Chicago Board of Education on the record on that now, because I haven't discussed it with them, so. But that's
fair.
not before this court.
That's fair, I get it. Okay. All right, so you're anxious to talk next?
I am, Judge, thank you. In the interest of trying to prioritize and organize some of the rabbit holes, Ms.
Can
Setterly
you
had a
say
couple...
your name again for the court
Sorry.
reporter? Thank
Robert
you.
Swain, thank you, Your Honor. Ms. Satterley had a couple points she wanted to address, specifically concerning the North Mac issues that Mr. DeVore discussed, that I think makes sense to touch upon quickly before I take us down a different rabbit hole.
Okay. So Ms. Satterley?
Thank you, Judge, and I'm gonna use the podium.
That's why we put it here.
Behind enemy lines here. So I think this will be.
Mr. Manning, you're behind him?
I think this will be a bit easier. I'm gonna keep my mask off. As you know, I'm Fraser Satterley. I'm counsel for North Mac CUSD 34, Yorkville 115, and Woodstock 200. There are claims or counts in Mr. DeVore's First Amendment complaint that are specific to North Mac, and I do want to address those from the court. You've heard a lot this afternoon.
We're not even going to get to it all.
My name, of North Mac, and of particular Judge Trumper. So I want to address that to the extent that Mr. DeVore cites Judge Trumper's orders as though they're the gospel truth. If we're going to put those out on the table, Your Honor, I think that we need to hear the whole ruling that Judge Trumper has made with respect to those orders.
I can read it. I don't need it read to me.
Can I read you the relevant provisions?
Yes, I just didn't want, because I know it's many pages.
Absolutely. And they are, it's just a finding, a specific finding,
Okay.
Your Honor, with respect to
Which order?
Student exclusion. Great question. There are two separate ones, Your Honor. One is the September 10th, 2021 order on the plaintiff's emergency motion for TRO.
And is that in, because I know she had a couple cases, that's in the one that was transferred here?
Yes, that is 2021 MR 91.
91.
Initially entitled Peters versus North Mac.
Okay.
In which Judge Trumper also certified the class.
Okay, thank you.
I digress on whether or not that was proper. That's not before the court at this time, but I will talk to you about the exclusion orders.
Okay.
Okay. They're also attached as exhibits to our pleadings in this matter, Your Honor, as
Okay.
exhibits 25 and 26 respectively.
Thank you.
In both of those cases. Now, it's certainly no mystery that Judge Trumper granted the plaintiff's TRO in the Peters case, and then she subsequently granted the preliminary injunction. But this is what she found specifically. Absent a finding by the local health department that this student and those in the potential class are deemed a close contact because of public health and welfare are significantly endangered, the defendants are not allowed to exclude these students from in-person learning, et cetera, et cetera.
Okay.
And it's that first part that's important, Your Honor, because on October 5th, 2021, plaintiff Stacy Buckaloo filed Mr. DeVore as her counsel, filed a petition for rule to show cause in that case, asserting that North Mac had excluded her student, KB, in violation of the court's preliminary injunction ruling, without a quarantine order from the local health department.
Okay.
Okay? Following a hearing on that matter, Your Honor, Judge Trumper said, counsel, my ruling is far more narrow than that. And in fact, when I say absent a finding by the local health department, that's what I mean. So I want to be clear on what Judge Trumper ultimately found. John, based on the facts that were shown, the school district did work in conjunction with the local health department and, without quarantine order, properly excluded that student from school. So her orders, particularly that preliminary injunction order, were not as broad and sweeping as Mr. DeVore suggests. Okay. So what does that mean here? Again, Judge Trumper found, to the extent we're relying on Judge Trumper's rulings, that these students are not entitled to the due process that Mr. DeVore asserts that they are entitled to under the Public Health Act. And that, in addition, that order doesn't say that these students are entitled to any other kind of process that the school board may provide them. In fact, her order was silent, and I think that speaks volumes, that they were entitled to any kind of hearing process in front of the school board or some kind of board-appointed or is-the-appointed hearing officer. There's nothing to suggest they're entitled to any kind of process, provided that the school had worked in conjunction with the local health department, which they did.
But isn't that what Mr. DeVore is trying to get done? I'm just going to ask you that. Once again, my circular. He wants the schools to work in accordance with the law, which is to work with the local health department in determining close contact.
But that's actually not what he specifically asked in this case, Your Honor.
Okay.
He's asking for a far more sweeping order from this court, asking that the school boards don't have any independent authority to make these decisions, regardless of whether or not the state mandates are in place. And that's the issue that that my clients take issue with, and that all of my co-counsel take issue with as well. And I know we have gone around and around, the various, I hate to say it, but the various lanes, okay? We keep coming back, it's all circular. Not necessarily. So I want to talk about another issue. But very quickly, to the extent that counts 1 and 2 remain against North Mac, that case has been, that is the law of the case, Your Honor. He's now coming back seeking the same temporary restraining order on the same issues that have already been decided. And in fact, there is no preliminary injunction currently pending against North Mac because Mr. DeVore and I agreed on the record on November 5th, right before he filed his first amendment complaint, to vacate the preliminary injunction. So that matter has been resolved. There should be no separate counts entered against North Mac.
Okay. That's good to know. Thank you.
I'm going to grab my water.
Yes.
That's fine. It's very hot here.
Yes. It's 78 degrees.
Now, we have talked a lot about due process, and we talked a lot about North Mac, so I want to go back to that. And Mr. DeVore can correct me if I'm wrong, but he's conceded in the Macoupin County matters that the school districts have the power to exclude symptomatic individuals. Tom, is that an accurate reinstatement of what was discussed in front of Judge Trumper?
Judge, none of the cases we had in front of the court had anything to do with children that were actively sick and exhibiting symptoms. That wasn't even in front of the court. So we're not here asking you to do anything with children who are sick. This case has nothing to do with that. So you take with that what you want.
Not entirely true. So, but I think that's a point that the court needs to consider. What about those symptomatic individuals? And we're saying we have the independent power to do this. Let's take a hypothetical. And I know the court doesn't like to deal in hypotheticals, but frankly, Mr. DeVore's filing is replete with hypotheticals, so I'm going to go down that particular rabbit hole. Let's say that a student shows up to school, and it's not COVID related. I'm talking, they show up with a fever. Well, I guess those are all COVID symptoms now.
Yeah, can you think of an example that is not COVID?
Let's say that it's a stomach, but let's say that we were pre-COVID. That's even better. Let's put it in the pre-COVID sphere.
All right.
A student shows up. They're vomiting. They have diarrhea. Sorry, TMI, but these are the symptoms that they have. They have a fever. The teacher says, honey, you're sick. You've got to go to the nurse's office. The nurse checks them over, calls the parents, and says, we're going to pick you up. You need to come pick up your child. They're sick. They're contagious. I believe that it's Mr. DeVore's assertion that if the parent says that this is a quarantine, if the school wants to exclude these students, and the school district would not have any independent power unless they had spoken to the local health department to exclude a student who's showing up with these symptoms.
I don't think so. I think he's talking about a chronic infectious disease, not something like that, because there are specific code provisions
Thank
in
you,
there
Judge.
that deal with a chronic infectious disease. I get your point if we weren't dealing with a chronic infectious disease.
Okay.
Go ahead.
I know, I'm trying to, okay.
Take your time. Don't worry about
chronic
it.
infectious disease. Okay. So are we talking about a flu then, Your Honor? I mean, not to ask rhetorical questions of the court, but I just want to be clear on where we stand.
I'm not making his argument.
I suppose my issue is this. At the end of the day, Mr. DeVore and these parents and their students are asking this court to make a ruling that chronic infectious disease, COVID, I'm not a medical expert. I certainly don't stand up here and pretend to be. If the flu is a chronic infectious disease, fine. I'm trying to think of others.
Ebola.
I don't know. Say it, Ebola. I don't know. Sure, Ebola. But I believe that it's their position that the school could not take any action to exclude these students. And I guess taking it a step further, what if a COVID-19 positive student who is asymptomatic wants to come back to school? And the parents say, I'm not going to quarantine this person. I think the argument is similarly being made. I think it's broad and sweeping enough that he's saying, well, a parent could say they're not sick, even though they tested positive. We don't believe that COVID is a real thing, and so you can't exclude them, asking something for the local health department. Now, in that particular instance, I believe, and I think Mr. DeWood will argue, that the local health department would step in and issue a quarantine order with respect to COVID.
Right.
But I think that that rationale applies with equal force to whatever the court is determining to be a non-communicable disease that may still be infectious. Pink eye, the flu, the 24-hour stomach bug. I don't know what viral family those live in, the norovirus, perhaps? Okay. But I think that's ultimately the question for the court. Are we really going to say, hate to do this too, but little Johnny shows up and the parents refuse to pick him up, and the school district has to have him in the school until the local health department comes in and issues a quarantine order? And I think that's the overarching issue. I want to bring up one other topic. Colleagues have certainly spoken about it. Mr. Brewer has alluded to the fact that these children are excluded and they don't have the right to participate in any extracurricular activities. I know that's a sad story, and students certainly enjoy participating in extracurriculars. It's an important part, of the school experience for a number of students. But our courts have held time and time again that students do not enjoy, it's not a right to an extracurricular activity, it's a privilege, and that can be taken away. So that leads into the next, to my next point, Your Honor. We're talking about, when we talk about masks, our position is that we can independently require them. I believe that you understand that from everything that my colleagues have said, but taking it a step further, and again, I understand that I may be talking in practicalities, but the fact remains that the school district does in fact have the authority to require students to wear other preventative measures, football helmets, glasses, and shop class. I don't believe that those are any different than what the court is considering here with respect to masking, and that it's being preventative. And we know that Foxfire stands for the proposition that not all preventative health measures are quarantine, and that's true here with respect to masks. And if that was the case, I suppose any student that didn't want to wear a football helmet, I don't know who that would be, but they could certainly then make the argument that they're entitled to some kind of separate due process here and not to wear that particular preventative device. I don't think that's what the legislature intended, and that's not how this particular statute should be read. I guess I would just make one other point, Your Honor. Mr. DeBoer talks about due process provided by enactment of the General Assembly to change the law. Comes back to that time and time again. If they want to do it, fix it. Right? That's what he said. I think that they have, Your Honor. And that's in the form of 10-30 of the school code, which provides the opportunity for remote and blended learning. Now, there are some particular allegations that seem to generally allude in count 1, and that's at paragraph 351 of the First Amendment complaint, that seem to allude.
Would you say paragraph 351?
Paragraph 351, Your Honor. And there are multiple subparts, but it's all there.
Okay, go ahead.
That appear to allude to the idea that North Mac doesn't have the independent authority to go into adaptive pause in conjunction with the local health department if the number of COVID cases or outbreaks in their schools warrant it. Again, with respect to North Mac, this matter's already been decided. In 2021, MR 89, Judge Trumper issued a ruling stating specifically that North Mac and Dr. J. Goebel have the authority to go into adaptive pause so long as it was done in conjunction with the local health department. Okay. So 10-30, and again, I know that I don't need to read this for the court, but I think it bears mentioning here. If the governor has declared a disaster due to a public health emergency pursuant to Section 7 of the Illinois Emergency Management Act, the state superintendent of education may declare a requirement to use remote learning days or blended remote learning days for a school district, multiple school district, a region, or the entire state.
Okay.
Your Honor, this particular provision allows for what is happening here with respect to student exclusion.
But I'm going to play devil's advocate. 'Cause
Sure.
I know that says that, but I can tell you, not all the schools have remote learning in process. Not the remote learning that we were used to when we were shut down. You know what I'm saying? Not all schools have the video capability where the students are interacting with the teachers.
And Your Honor, that may be the case. I can't speak to all
Right.
145 school
That's what I'm
districts,
saying. I'm just throwing it out
But I
again.
would note that that's not actually pled in Mr. DeVore's pleading.
Okay.
There is no allegation that any of the 145 school districts that are named in this complaint do not have the capability or the capacity to provide their students with remote learning. And that's a very important distinction. It goes to irreparable harm as well, because there are no factual allegations with respect to what any of these districts are doing with respect to these students or their policies. In any event, going back to 10-30, the legislature, the General Assembly took this action effective 6/18 of 2020, so at the height of the pandemic. So it did take action,
Right.
and it allows the state.
So they can, right?
I'm sorry?
They can take action.
They can, and they did. And they said.
But not with regard to due process.
And they-
That's outlined in the
Well, I
statute.
want to get to that.
Okay.
Because the IDPH, and my colleagues have said it ad nauseum, but if they're repeating, IDPH does not apply to what the school district is doing here. But let's extrapolate what 10-30 says the state superintendent has the power to do.
I'm sorry, which one?
10-30.
Okay.
Okay.
Go
The
ahead.
General Assembly has vested in the state superintendent the authority to put school districts into adaptive pause for a period of time as she deems fit based on numbers. School, a single school, a multiple school, a region, a district, the entire state. That means that those students can be excluded without due process, because what is also not in the statute, Your Honor, is any reference whatsoever to a parent's ability or group of parents or teacher's ability to any recourse for the state superintendent's decision on 10-30 to include active pause. If they have the right, there is no right to an in-person education, and we may quibble about that fact, but that's our position. And this makes, the General Assembly then took the action to show that this is very clearly the case. You don't have to be there in person, but you've got to provide it remotely, and we have the authority, and the state superintendent has the authority to make that decision. And if the state superintendent has the authority to make that decision with respect to the entire state, certainly the school districts have the ability to make that decision with respect to individual students for a very brief period of time to be excluded because they're close contacts if they have this access to remote learning. And they do. And the legislature has provided for it. Mr. DeVore also indicated or stated that a district can operate its schools, but it can't engage in public health. It's not engaging in public health, Your Honor. It's taking action that's necessary for the safe and efficient operation of their schools. And I mean, that's ultimately, and I can see you ultimately may disagree with me, but I think that's ultimately going to be the deciding factor here. The school has the ability to make those decisions. That's all I
So
have.
once this
Sure.
public health crisis or whatever is over, so can the school board still mandate that the students wear masks? Because you're saying we have all this independent authority, so let's say COVID stops February 1st, miraculously.
Sure.
So you're
Yes.
telling me the school board can still say to the students, you still have to wear a mask because of our independent authority that's set forth to school boards?
Yes, I do believe that the school boards, now, I don't know that any of them are going to do that, that's entirely speculative.
I'm just
I
doing
don't
a
think that
hypothetical.
anyone, nor do I think that anyone wants to, Your Honor. Do they have the authority to? Yes, they do. I mean, this is not exactly on all fours with the situation we're facing here, but this is maybe a helpful analogy. When the pre-COVID and after COVID, we're no longer in a state of emergency, or the state mandates have been lifted. School districts can also continue to require cafeteria workers and food handlers to wear hairnets, masks, and gloves. And I don't think that anybody's going to balk about having those folks do that, because it's for the public health and safety of the students and the staff members who are in the school. I don't see that this is that much different. Though obviously Mr. DeBoer seems to feel otherwise, which he's entitled to do. But ultimately, these safety measures are in place, and yes, the school districts have the ability to make these decisions, regardless of whether or not the emergency orders, or sorry, the executive orders are in place, or there's an emergency, public health emergency, as declared by the governor.
Okay.
Thank you.
Mr. DeVore.
Oh, Judge. First of all, I don't know why we're talking about football helmets. Got nothing to do with this case. Extracurricular activities, nothing to do with this case. Paragraph 358, at all times, the students are not currently positive for COVID. At all times relevant, the students are not exhibiting symptoms consistent with COVID. This case has nothing to do with kids walking into a school building sick and being able to say, you can't send me home without due process. That doesn't even make any sense. We've never taken that position. I'm going to come back to Judge Trompert a little bit, because I really need you to understand what those orders were about. They were completely mischaracterized to you. But before we do that, let's talk about the legislative enactment of 10-30.
Okay.
Who did the legislature give permission to put school districts on remote or blended learning, if necessary? Not the school districts. The state superintendent, Dr. Ayala. She has the power. That's who the legislature gave it to. Are they going to stand here and say, well, regardless of that, we can do it because we got our inherent power? No, they're not going to say that. They might, I guess. But you know what? The enactment of that legislative act in and of itself was due process. Legislature passed it and said, Dr. Ayala can, under certain circumstances, put a whole district or the state and go home, all of you. Judge, you can't say that what that means is, since superintendent has the ability to do that, that means the school districts can pick kids out of the bunch and say, you go home, you go home, you go home, because we think you're a public health risk. That's not even an analogy that you can make. It's completely two different conversations. But regardless of that, that doesn't give the school district, that provision gives the school districts no authority. To the contrary, it makes it clear that they don't have it. And that's actually what Judge Tromper said. She said, if you're going to put your school on this adaptive pause, I like that. School closures are now called adaptive pause. I like the words it create. But you had to do that in conjunction with your local health department. Because when that case got filed in Macoupin County by my clients, what happened? Within a day or two, they shut the whole school down. Judge Trumper entered an order and said, no, if you're going to do that, you got to do that, and it has to be based upon metrics that make sense with the health department. So that's what that order said. But again, Dr. Ayala has the power. She got legislative power. I'm not here arguing about that. She wants to put the whole state back on remote learning. Go ahead. I don't like it. But you're not going to hit me arguing that the legislature didn't have the power to do that, because they did. If people in this room don't like that, then don't vote for your representative at the next election. Now let's go to the injunction that she talked about. Judge Tromper, read her orders, please.
Okay.
All of them. She entered a temporary restraining order that said the school district does not have the ability to exclude a kid from school without them getting due process. What happened after she entered that order and then a little time continued? The emergency rule change. The emergency rule change completely tried to strip all of that basis of which she entered that order away. And so when she entered her preliminary injunction, and also on that same day entered the request for necessary parties, she entered an order based upon that emergency rule still being presumed to be lawful because it was not in front of her to override that. And that emergency rule change, one of its attempted purposes is to strip those due process requirements. And so she was not in a position to do anything. And that's why her ruling, and again, Ms. Satterley properly read it, when the judge ruled that, yeah, the school district in conjunction with the health department can exclude a kid from school without due process because that's what that emergency rule tried to take away. And it wasn't in front of her to be able to pick that apart because, again, we had not yet, then as soon as they entered that emergency rule, then here we come, we got to sue the State Department of Health, and we got to sue ISB and the governor. That had not come in front of Judge Trump yet. So she was stuck with the emergency rule as it existed and was not in a position to disregard it. So that was the difference. If you read her injunction and you read her temporary restraining order, you'll see the difference, and the difference was that she was accepting the rule as it had been modified on an emergency basis because, again, she didn't have the benefit of where you sit now to say, I'm going to take a look at that. And procedurally or substantively, does that rule have the ability to do what she had to accept that it was doing when she entered that order, ma'am? Okay, that's what really happened there. And I wanted to make sure you understood that. Thank you.
All right, Nancy. Mr. Swain?
Robert Swain, Judge.
All right.
Judge, I promised you some answers on some of your questions concerning due process and interplay between IDPH and school boards. And I want to start by reiterating the point Ms. McCorney made, that the Department of Public Health and local school districts operate in different spheres of jurisdiction. And part of the reason why, first thing this morning, I articulated the 11 school districts who I'm here to represent today is that while Ms. McCorney is here to represent Chicago Public Schools, which on a state level is obviously kind of the gorilla in the room, I'm representing school districts everywhere from Lake County down to Monroe County, okay, across the state. Okay? This is, as one of my other friends here in the room said, this involves the biggest school districts and the smallest school districts. But I think to get to some of the answers of these questions that are troubling you, and I think there are some of the defects and some of the theories that we're hearing from the plaintiffs, we have to start with some first principles. And the first is this. There is a constitutional dimension to public education here in the state of Illinois. Article 10 of the Illinois Constitution requires provision of public education to students. It puts the burden upon the General Assembly to establish a system of public schools. It's one of the few government services that's actually constitutionally guaranteed here in the state of Illinois. And that provision in Article 10 and that delegation to the General Assembly in the Illinois Constitution has some significant implications. It means that the General Assembly alone has the authority to regulate public schools. And there is a line of cases, we cite them in our brief, from the Illinois Supreme Court, examining this issue when some of these questions have arisen over the years. The two most important are the City of Peoria case and Gerba versus School District 155.
Can you spell that? I'm sure the court reporter will.
G-U-R-B-A.
Okay. Gerba versus who, I'm sorry?
Versus School District 155.
155? Thank you.
In the Gerba case, for example, the issue was whether public school districts were required to comply with local municipal zoning. And the argument was, General Assembly has exclusive jurisdiction to regulate school buildings, not local municipalities. And that dispute went up to the Illinois Supreme Court. And the Illinois Supreme Court said, well, actually, when we look in the school code, we do find a provision in the school code adopted by the General Assembly that says school boards should participate in zoning. And hence, having found this statement by the General Assembly that opens the door for municipalities to regulate school properties, yes, school district, you must participate in zoning. But it was dependent upon finding that provision in the school code.
Okay.
The city of Peoria case is even more stark. In the city of Peoria case, the city of Peoria adopted an amusement tax. And they wanted both the local park district and the local school district to collect amusement tax at their events. And when that dispute got to the Illinois Supreme Court, one of them won, and one of them lost, Judge. The Illinois Supreme Court said, well, actually, school district, you are subject to the exclusive jurisdiction of the General Assembly. In the language from the city of Peoria court. Quote, the requirements of the ordinances, the amusement tax ordinances, the requirements of the ordinances impose upon the Board of Education duties over and above those that have been imposed upon the board by this legislature. They also confer on the school district powers that they have not been given by the statute being the school code. As applied to School District 150, the two ordinances in question constitute an unauthorized regulation of the school district, contrary to Section 1 of Article 10 of the Constitution of 1970. That's the City of Peoria case, 76 ill second at page 476. The Park District didn't have that imprimatur of constitutional operation. They didn't have that exclusive operation of being established by the General Assembly to discharge that constitutional function. So the park districts, to put it bluntly, were out of luck. Park districts, they were out of luck. The park district lost the case for that reason, but the school district won.
Okay.
Now that constitutional principle that public schools in Illinois are regulated by the General Assembly, okay, means we have to look at these interpretations that are being urged upon the court of the Department of Public Health Act to determine whether we can find any delegation in the General Assembly or in that act by the General Assembly that says, yes, you Department of Public Health Act, we are giving you authority to tell schools when they can or cannot send kids home, whether they can or cannot require kids to wear masks, etc. There's nothing of that sort in the Department of Public Health Act. And as Mr. Percorni pointed out, it's an authorizing statute establishing powers of that department. And in fact, we've heard so much about Part 2305, the statute. We've heard so much about the quarantine and isolation powers conferred upon the Department of Public Health pursuant to that statute to confine people to their homes or to a hospital, okay, against their will, not simply to regulate what goes on inside a school. But it's Section 2M of the same section. We've heard so much about 2B and 2C. If we scroll down to 2M of that section, 20 ILCS 2305/2M, the individual provisions of subsections A through H of this section apply to any order issued by the department under this section. The Department of Public Health Act gives power to the Department of Public Health to issue quarantine orders governing the public at large. There's nothing in the Department of Public Health Act that gives the Department of Public Health jurisdiction from the General Assembly to come in and take those same actions inside a school. Not here. Now, we went on to examine in our brief there are a couple provisions in the school code that actually specifically allow the Department of Public Health to participate in the operation of schools. We looked at one of them a few minutes ago. Okay. Section 27-8.1 has to do with immunizations of students. And the General Assembly has said in the school code, actually, Department of Public Health, you're in charge of deciding which immunizations kids need in order to attend school. And we go to our pediatricians and we have that form, it's got an IDPH logo at the top, because the IDPH has determined through rule which immunizations are required to enter into school. And then when there's there's language referring to the exclusion provisions in that same section, it is for students who have failed to comply with those immunizations. It's not a wholesale adoption that suggests exclusion of sick kids or asymptomatic contacts have to be determined by the Department of Public Health. The next closest section, we spoke a little bit about this on Monday, is 10-21.11. 10-21.11 says school boards, locally elected school boards, shall adopt infectious disease policies not inconsistent with guidelines provided by the State Board of Education and the Department of Public Health. Now, to my eye, that actually seems to be the exact guidance that we've gotten, and it's been amended several times from ISB and IDPH
Yeah, and
about
I'm
COVID
going to
measures.
stop you there, because that's the
Yeah.
perfect opportunity for me to ask you about this.
Yeah.
Because I have the joint guidance by ISB
Yep.
and ISB. You know, I went back and I found the 2003 edition of the joint guidance. And I looked in there, and it says, and I don't know if you can answer this, I'm not putting you on the spot, it goes to anyone.
I will try, but Judge, you have an impressive collection of school attorneys in
It
the
says here that the Illinois General Assembly places high priority on the need to prevent the spread of infectious diseases. And then they cite to 105 ILCS, you know, the school code, requires school boards to develop policies related to the appropriate manner managing children with chronic diseases, everything that we have talked about.
Sure.
And then if you go in here, it talks about legal considerations related to chronic infectious diseases, protections incorporated in the statutes. Federal and state courts have held that children who have chronic infectious diseases are entitled to a free, appropriate public education in the least restrictive environment. And then over here, it says each student should have the right to due process. Exclusion from the school should not be construed as the only response to reduce risk of transmission. The school district should be flexible in its response and should attempt to use the least restrictive means to accommodate the student's needs. I could go on and what I highlighted in here. And for some reason, after COVID started, they felt the need to change the joint guidance. And I don't know why, we're still dealing with COVID. And they felt here the thing with what you're arguing to me today. This is kind of a rhetorical question, but I point that out because you are arguing about your independent authority, which I get. But obviously the courts have felt that children are entitled to due process.
Of course children are entitled to due process. But let's move to the second point, okay? My first point to sum up is that the interpretation of the Department of Public Health Act and even Department of Public Health regulations that the plaintiffs are trying to impose upon schools violates Article 10 of the Illinois Constitution. Because the General Assembly has not invited the Department of Public Health in to actually impose those restrictions upon schools. But now I'd like to get to your second question. And this is the second issue of constitutional importance. We have heard about due process, well, probably more times than we have parties in the case. Okay? But I find myself a little bit Monday, and much more so today, every time I think that I understand the due process theory that's being advanced here by the plaintiffs, and every time I think I can nail it to the wall, it turns out to just be a different flavor of Jell-O. And here's what I mean. On one level, when there are rules of general application being adopted through a legislative process, there are not individual rights to individual due process hearings prior to those rules being adopted. This is from the U.S. Supreme Court.
Can you say that one more time?
Sure.
They're not individual rights.
I'll do better than that, Judge. This is bimetallic, bimetallic investment company versus State Board of Equalization. 239 U.S. 441.
Yeah.
1915, 100 years ago, as we've been extolling our authority today. This was written by a judge named Holmes on the Supreme Court, Justice Holmes.
Okay.
Where a rule of conduct applies to more than a few people, it is impractical that everyone should have a direct voice in its adoption. The Constitution does not require all public acts to be done in town meeting or an assembly of the whole. General statutes within the state power are passed that affect the person, property of individuals, sometimes to the point of ruin, without giving them a chance to be heard. Their rights are protected in the only way that they can be in a complex society, by their power, immediate or remote, over those who make the rule. That's 239 U.S. 445.
445?
445.
Oh, I thought you said 1. Okay, thank you.
And I think actually Mr. DeVore may agree with this point to some respect, because he just made the observation that if any of us in the room don't like the laws that are on the books, we've all got to vote to take to the ballot box and either vote bums in or vote bums out. But due process on that legislative level operates through the political process. When rules of general application are adopted at the outset, there's not a requirement to be conducting individual due process hearings by every single person who is affected. The Illinois Supreme Court, okay, has taken the same position. And just by one example, this is in our briefs, Advanced Systems, Inc. versus Johnson, 126, Ill 2nd, 484. It's from 1989, a little bit less than 100 years.
484, you said?
484.
Thank you.
The Advanced Systems Court, the Illinois Supreme Court, said, so there's a distinction in administrative law on the type of hearing that is necessary to meet due process requirements in determining legislative fact as opposed to adjudicative facts. Trial-type procedures, including the taking of evidence subject to cross-examination, are required when individualized interests are at stake and specific facts are in dispute. Now, what I think I've heard Mr. DeVore say multiple times, not just today, is that parents, or students through their parents, have a due process right to object to the adoption of, let's say, the mask rule before it's imposed upon them in the first place. Bimetallic Advanced Systems, that line of cases say, no, your due process in connection with adopting the rule of general application is that you are able to participate in the political process itself. But if there is an individualized issue, here's where I really have trouble understanding where the theory goes. Because due process does not exist in the abstract. Again, other judges have said it better than I. This is from the Illinois Supreme Court. Big Sky Excavating, Inc. versus Illinois Bell Telephone Company, 217 Ill 2nd 221 at 241 from 2005.
Give me that one more time.
course.
217, ill second.
221.
Thank you.
Comma, 241.
241, thank you.
2005. I'll be honest, I don't think I knew that Illinois Bell was still around in 2005. Quote, there is no due process right in the abstract. In undertaking any due process analysis, one must first ascertain that a protected interest has been interfered with by the state. Then, and only then, does one consider what process is due. If no protected interest is present, due process protections are not triggered. That's Big Sky Excavating. Here's another short sentence really summing it up well. This from the 1st District in 1998. Peterson versus Chicago Plan Commission. 302 Illap 3rd, 461 at 466. The starting point in any procedural due process analysis is a determination of whether one of the constitutionally protectable interests is present. And what are those interests protected by due process? Life, liberty, and property. Now, for the umpteen number of times that I've heard due process asserted by these plaintiffs, I have not once heard them suggest whether we are dealing with a deprivation of life or a deprivation of property or a deprivation of liberty, much less try to conduct an analysis of whether there is a deprivation, and then much less whether to take that second step of determining what process is due. So again, in a vacuum, we did our best in our brief. And I think reading 477 paragraphs of the complaint as charitably as we can, two things strike me. The first, I think they might suggest, is that being required to wear a mask at school is a deprivation of a protected liberty interest. I think that's probably what they might argue. But let's look at student liberty interests in schools. And let's bear in mind, hearkening back now to some of Mr. Picorni's points, that school children in schools are subject to the authority of school officials who are standing in the place of parents in loco parentis. It literally means that they have the rights and responsibilities for that student, the same rights and responsibilities for that student at school as a parent would outside of school. And that operates both, of course, in the terms of responsibility to protect those children, but also in the terms of supervisory rights and to control what they're doing in the schools. That's examined quite well. It comes from section 24-24 of the school code. We've discussed that. It's examined quite well in the Kobolansky case in the Illinois Supreme Court.
Can you spell that for the court reporter?
Of course. Kobyllanski. Kobolansky is 63 ill second 165. Now, there were some passing comments about, and again, quite accurately, by Mr. Picorni, that in some very real sense, school is a place where kids are told to do things they don't want to do. At the risk of stating some of the obvious, okay? But I think it's important to appreciate how obvious that point is. This is not a public health official. This is not the Department of Public Health. I'm gesturing fondly to Mr. Verticchio, okay? Imposing a quarantine order against, forget the term, a free adult in free society. Okay? The liberty interests of students in schools are far less than even it is for students in the rest of society. Okay? How do we know that? That general principle comes again from places like the U.S. Supreme Court. Tinker versus Des Moines.
Did you say Tinker?
Tinker.
Okay.
393 U.S. 503, 1969. We all know Tinker is the Vietnam-era armband case concerning student free speech, right? But here is an important principle that undergirded that entire analysis. Constitutional rights of students must be, quote, applied in the light of the special characteristics of the school environment. 393 U.S. at 506. We have laws on the books in the state of Illinois compelling children to attend school up until the age of majority. Those laws have been found constitutional by the Illinois Supreme Court. Lewis versus Spagnolo, S-P-A-G-N-O-L-O, 186, Ill 2nd, 198. And the compulsory education laws were upheld against a due process challenge because the Illinois Supreme Court found there was no protected liberty interest being infringed by requiring children by law to go to school, or at least to be educated, be they homeschooled. The very fact that they must participate in the education system itself sounds striking as a member of a free society, but is not infringing a protected constitutional liberty. And when they come to school under compulsion of law, without having violated any of those liberty interests, what do? We tell them when to arrive, when to leave, where to sit, what to do, what to read, with whom they must be working in a freedom of association sense. To think of these school children subject to all these rules, at the discretion of school officials who are standing in the place of parents and guardians, implementing, among other things, a chronic infectious disease policy that is adopted locally by the local school board within guidelines from ISB and IDPH, but nonetheless finalized locally to reflect local policies and priorities and conditions, because school boards are elected officials. Okay? If one aspect of that is that under pandemic conditions, the school board decides, we think it's wise right now for children to wear masks in schools, again, putting aside the question of those decisions being taken away from the local schools and made on a state level, but on a local level, of course the school boards have the authority to say, yes, right now, in our position as in local parentis, parents and guardians responsible for the children under our roof, in our buildings, we're going to require you to wear masks. And sure, if COVID goes away February 1, and whoever has that magic wand, they can't set the price high enough, of course, right? If COVID went away February 1, and the school board said, well, we want to wear the masks anyway, well, sure, they're still going to be subject to the general principle that the policies can't be arbitrary or unreasonable or capricious. But that's the very role, the very point of how a policy-making body operates. Subject only to those outer limit of judicial review for arbitrariness and capriciousness and reasonableness, they have under the school code the authority to decide for themselves what is the best to be doing in their schools for the students in their community for whom they are responsible. and it's because the General Assembly said so, because the Illinois Constitution says it's the General Assembly who gets to make that decision in the first place. Now, okay, we've gotten all the way to the point of adopting these rules of general application, okay, through perhaps a local process, okay? Believe me, I know I can speak for all my colleagues, sight unseen, we've been through many difficult school board meetings
I can't even
in the
imagine.
last 4, 5, 6 months where return to learn plans were specifically being considered and reviewed, okay? Many difficult conversations, many divergent interests in many different communities. Okay, as I said, I'm here to represent schools from all over the state, as are my friends. And part of the reason why we're allowing Mr. Verticchio to defend the state level issues is because we need to be concerned on behalf of our clients with that local authority we have as school boards. So once we've done that and satisfied due process by adopting that rule of general application up front, then we get to the question. If there is an individualized deprivation, okay, then what processes do? So I was, to rewind a few minutes, searching for any individualized deprivation that might be implicating individualized due process. And I just don't see any way to find that there's a liberty interest. And again, I'm operating in the dark because the plaintiffs haven't even recognized or acknowledged, much less attempted to carry this burden.
To what?
They haven't even to carry this burden.
Carry
This
the
is their
burden.
burden to carry, Judge, okay? I'm trying to respond to their arguments in the vacuum. Here's the other argument that strikes me as something that I might in Mr. DeVore's shoes raise. If I can't find a liberty interest, students do have, and there's no argument here, and I think no arguments from my colleagues, do have a protected property interest in accessing their education, of course. Certainly not going to get any of our clients to suggest that education is important to kids, right? Okay? But the cases do clearly say, surely, okay, this is Goss versus Lopez in the U.S. Supreme Court. Okay, this is Colquitt, C-O-L-Q-U-I-T-T, versus Rich Township High School in the Illinois Appellate Court. Goss versus Lopez is 419 U.S. 565. Colquitt versus Rich Township is 298 Illap 3rd, 856. Those cases will say, get away from COVID for a minute, when we suspend or expel kids for disciplinary reasons, but there's due process required. We do that all the time. Okay? We hold those hearings with school boards, we defend those decisions in court. Amen. And why is due process required? Because when we suspend and expel someone from school, we're saying, you know what? You have done something bad enough, with enough background. There are many factors going into the decision, okay? You've done something bad enough with enough other circumstances involved that we're going to expel you from school for up to 2 calendar years under the school code. You don't get to come to school. You can't come to school events. You don't get to video in. You don't get to Zoom in. You don't get work sent home. You get homeschooled. You go to private school. But the public school system is done with you, little Johnny, for 2 years because you did something, okay? Okay? And again, but we hear about these cases too, right? Guns, drugs, okay? We know what that due process is, and we know what that deprivation is. They're being deprived of their education. So of course we provide them with due process. But what I see in the complaint and here in the motion and in the argument, again, not always quite consistently as I try to keep it in a lane, when someone is a close contact, okay, they're excluded from the building, they're not being suspended or expelled from the entire educational system. Now, you make a very astute point, okay? that some schools may or may not be implementing more or less of the remote options that we did or did not have previously, okay? But number one, those remote platforms, as well built as they were, are not the only way to provide education to a student who is not currently inside the school building, okay? We also implement things all the time of sending work home, providing tutoring, catching them up when they come back. Okay? We have kids who are sick all the time and miss time from school. Teachers know how to keep kids up to date in the loop. It's not ideal, but kids miss school all the time. And our teachers and our principals in our schools know how to keep those kids moving forward in their education, and that's what they're doing now. They can't let the kid into the building, but they're not suspending them from the public education system. Certainly aren't expelling them from the public education system. They're providing them with education in some other fashion. Now, what are the specifics of that? For however many plaintiffs we have, okay, who apparently have never been sick, so they've never been excluded from their schools. Again, I start to break down on what the theory is here, okay? You know, if there really was some allegation that Johnny was excluded as a close contact, and the school wouldn't answer their calls or emails for 2 weeks, and Johnny got no education at all for 2 weeks, well, yeah, in some extreme circumstance, I suppose you might be able to find there's been a deprivation of education in that circumstance. But that's nothing that's being alleged here. Certainly, I don't think anything's being alleged as a common experience of 900,000 students in a putative class. There are individual parents with individual students who think that they suffered a constitutional deprivation of a protected property right in education, then by all means, come forward. But that's not that's not the broad brush we're painting here. So I find myself, notwithstanding the importance of due process as a concept, also struggling to actually understand what due process is being asserted, and more importantly, what protected interest on a class level the plaintiff's claim is being deprived. Because if there is not a loss of a protected interest, then we don't implicate due process in the first place. First note I took, first thing this morning, I think the first case Mr. DeVore cited, Youngstown Steel. Government seized the steel mills. That's a deprivation of property. That's exactly what I've been trying to find in the papers here. Where is there a deprivation of property being alleged? So in short, Judge,
Sorry, sir.
I
apologize.
My wife and children are with you, believe me. Due process doesn't exist in the abstract. I have heard it thrown around as an abstract term for so many hours now in your courtroom here, just over these last few days, and in papers that have been filed in these millions of pages. But there's an analysis that applies to due process. Okay? If we're talking about adopting the rule on the front end, the legislative process, be it state level or local, that's what satisfies due process, the political process. If it's an individualized deprivation, then I need to understand, because I haven't heard, either the liberty interest or the protected property interest of which people are being deprived. Because I haven't heard that at all, either on individualized bases, in which case individual plaintiffs might have rights to individual due process, but I haven't heard it at all in a broad brush level. There's divorce coming with these 700 some plaintiffs and 900,000 some punitive class members. If there isn't a due process theory, there isn't an ascertainable right that needs to be protected, there isn't a likelihood of success, there isn't a harm they are suffering, we can take that last step of putting these observations into the TRO analysis, but that part's pretty straightforward.
Okay,
Thank you.
thank you. How long do you have, Mr. DeVore? First of all, are
Yes,
you
ma'am.
all right, Madam Court Reporter? If you have to leave, you can leave. Because court closes at 4:30, so. All right, go ahead, Mr. DeVore.
Judge, with all due respect to my colleague, when we first started that off an hour ago, he talked about Jell-O, suggesting that that was what we were presenting, and I listened as hard as I could listen. I'm a pretty good listener. And most of what I just heard escaped me. It really did. I mean, we all as jurists, we have that appreciation. If something gets presented that's pretty straightforward, but you don't like it, obfuscate the heck out of it. Make it sound like it's some big, grandiose, complicated matter to try to blur it. I've done it before. I'm not going to lie, I've done it before. Many times the court sees through it, and I hope today that you do, ma'am. A few of the things I got to cover. My colleague talks about immunizations, fitness, and if you don't do that, you get excluded. Remember we were talking about that? Guess where that comes from, Judge? The legislature. They passed that law. Put it in the school code. If you listen to most of what you've been hearing, well, we got this inherent power. And we don't, but the legislature must not believe that because they passed that specific provision. Now, I do agree that there is a part of due process that has to do with legislative enactment. Absolutely. And also, counsel talks about, well, when we, as local governing bodies and school districts, and we go through and we have open meetings and hearings and we adopt policy, etc., that's due process. It's true, but that doesn't mean they can adopt whatever they want, and their constituents have to accept it if what they adopted was not in their power to adopt. And that's what you're being asked to do. Now, I like how he said, well, the General Assembly has complete control over schools. They do. They have control pretty much over everything. And there's nothing to suggest that the Department of Health is the one that controls these issues. And I opened up the Department of Public Health Act, and it has supreme authority in matters of quarantine and isolation. And I can go on, may declare and enforce quarantine, etc. Supreme authority seems pretty significant to me. It doesn't say, well, we have supreme authority. We've given that to the Department of Health, except the school districts. They can do whatever they want. It doesn't say that in here. And then he talked about, well, I haven't heard anything about liberty interest or property interest, etc. He's making a constitutional, procedural, and substantive due process analysis when we're in here making a statutory procedural and due process request to you. It's in the law, Judge. Now, you can decide for yourself whether or not you believe the Department of Public Health Act applies to these children. I'm suggesting to you it does. There's nothing to say the school code gives them the ability to disregard it. But if you read the, again, legislatively adopted Health Act, it says in there, this is your rights when we're dealing with issues of trying to suppress infectious diseases. These are your rights as citizens. Children have those rights too. Now, if you recall, remember, the health department tried to strip it out, but the modified quarantine had exclusion from school in it as a type of quarantine. Right?
Yep.
So clearly, The state agency, the Department of Health, who has supreme authority, is of the opinion that school exclusion and sending a kid out of a school is an issue of quarantine. They have that opinion. Now, granted, they September 17th tried to pull that away. The court knows that story already. Set that aside. This whole issue that we can exclude kids from school for issues related to the matters of public health, we can do. It's not a state health issue. Health department, state disagrees with them. And again, we're not going to get to it today, but I look forward to see if Mr. Verticchio wants to touch that fireball of whether or not these school districts have so much power that they can do what they want. And the State Department of Health, who's his client, doesn't have any horse in that race. I really want to hear that. Because I think they'll probably disagree. Again, when they talked about Section 8.1 of the school code that deals with the immunizations and stuff, it expressly authorizes exclusion, Judge, if children don't follow those immunizations. Expressly authorizes it. That is a clear indication to you that if a child, and the council agrees, their school, their education is a property interest, if you're going to exclude them for a public health reason, which is a matter for immunizations, the legislature had to authorize that. And they did. These cases that were cited about zoning and tax and stuff, that's not even on point. Again, we are dealing with issues of public health. Public health. We have to confine our analysis to that. We're not talking about due process in the abstract whatsoever. We're talking about due process as it's written. I don't have to go in and read it to you. But it says the Department of Public Health can do these things. There's a supreme authority. It's pretty straightforward. But yet we sit here in front of you and listen to lengthy argument that says all of that written in the law and all of that analysis that's been done by other people that sit where you sit that say, yes, these children have these rights. It's all wrong. We're school districts. We can do whatever we want. We set, I don't know the fancy Latin word, loco parentis or whatever they call it. That doesn't give them the ability to disregard the rights of these children. And they talk about the due process that children get if they're going to be disciplined for, again, every lawyer in here knows it's over how many days they have to get due process. Is it 10 maybe? I'm not sure. But Judge, with this, they're saying, well, if you don't wear your mask, you just got to go home. Go home for how long? Oh, we don't have to give you due process for that, though. We have to discipline you because you were Johnny was a little bad boy, then maybe there's due process. But if we're trying to make you wear a mask, then we can just send you home. Because they talk about, well, we're not taking your education away from you. You can still do the remote learning. Read what Judge Trumper thought about that. She found that these children have a right to be in that school and being educated. That was the whole purpose, Your Honor, of Section 10-30 that Ms. Sackler talked to you about. Because within the statute, there are so many school days that have to be had for children, because we all as adults in this room know that children being in school is what it takes. We know that. That's why there's a requirement in the statute that says so many school days. That exception that the legislature put in is saying that if the state superintendent believes it's necessary to go remote, that it doesn't count against that school district for the school days. So clearly being in school is a protectable interest. Clearly it is. And Judge, to suggest that the law as written is not clear that it was giving the Department of Health control over these types of matters, you're just not reading the law. Again, you're going to read it for yourself. I'm not going to sit here and read it for you. And to come up with these obscure, well, it doesn't cover these types of issues. Yes, it does, Judge. It clearly covers them. Thank you.
No. Our court closes at 4:30. I'm not going to mandate that my staff stay longer.
Yes, ma'am.
We just need to address, obviously everyone wants to be heard. oral arguments are a privilege, not a right, but this is a huge issue. So, for those, I don't know, was everyone here on Monday? Defendant, counsel?
No.
The problem is, I have a very full calendar, to the extent I'm booking out into April. How my calendar works, I have a civil week, then I have a felony week. I have a civil week, then a felony week. My civil weeks, which are you guys, are packed. My felony weeks are open in case a felony announces ready for trial, I go to trial. So what I did on Monday is I told the attorneys I would talk with the chief judge and see if I could use some days in my felony week to address this, because otherwise I would be giving you a hearing in March or April. So I would propose the same to the attorneys today, because I did get permission for the other case to have arguments on the 19th. I just haven't had an opportunity to send anyone an email. I did put it in a docket entry, but I don't know if that has gone out to the attorneys as well. But if everyone wants a chance at arguments, we need to have another day. I would like to hear from Mr. Verticchio.
Thank you, Your Honor.
And I do know there's some others who are chomping. And then I didn't even get to hear from you, counsel, Mr. Gerber.
Like to at least address the 3 counts in our complaint. If the court was to rule in relation to, in our favor, the specific counts towards the districts, frankly, would be somewhat moot. So if the court would prefer, we can proceed on count 1, 2, and 5 for purpose of the record in my complaint, just to expedite the issue. Depending upon how the court rules, we can address the other counts later on, just to assist the court with some of this.
And that's an 03, right?
Yes, ma'am. And count 2 in that, judge, is the due process issue, like I say, which is duplicative, so there won't be much, just some minor points to touch on. Counts 1 and 5 that would be addressed mostly against the state parties.
Okay. So I will tell you, I have preliminary hearings on January 27th. Again, a felony. I could probably, no, that's not gonna work. Forget it. I'm gonna have to email the attorneys, because I'm looking already into March, and that's just not fair. I'm gonna have to see if I can rearrange some civil matters. And see if I can, the problem is I'm just gonna have to give you a date, and then you're just gonna have to hopefully.
We'll make it work, Judge.
I know there are multiple attorneys who have entered their appearance under one firm, so hopefully someone can come. But I'm gonna have to take tomorrow, and I'm gonna have to try and rearrange stuff on my calendar. In particular, I will tell you, the week, I know it's not ideal, but the week of February 18th, I have, nope, that's not gonna work. Forget that. February 14th, I have a felony trial scheduled that week as a date certain that it's going. I will reach out to the attorneys and see if it still is going, because that was set in December. And if it's not, then I have that entire week free unless some other felony announces ready. But then I could see if another judge could cover that trial. But I will try to rearrange my civil calendar so I can get you a date before then, because I personally don't want to wait that long, because I like to do things while they're fresh in my head. So if I could indulge everyone for your patience, let me work on something tomorrow, see if I can get some stuff rearranged or get some judges to cover some stuff. And then I can send, I'm going to use the email. I like to use the email sent out by the state because they tend to have everyone on there to respond, and hopefully I'll catch everyone, because I have not yet created a group with everyone's emails in it yet. And if for some reason, worst case scenario, there'll be a docket entry, okay? And the clerk will get that sent out to everyone who has entered their appearance. But I appreciate the argument today. I'm sorry we did not get to everyone. But I will do my best tomorrow to try and rearrange my calendar so we can get it